Yes.
My lord, I'm mentioning for listing one land matter, my lord. By last date on January, my lord, the respondent was directed to make an assessment of my zirat and submit a report within 4 weeks. Now that they have not done, and the matter may be listed on 4th of April, my lord. Till now, they have not doing anything, my lord. But my lord, one more matter, my lord. I'm sorry, my lord. Another matter, my lord, 2019, my lord. This may also be listed on 4th of April. Same district, my lord.
Make please, Lordship. Lordship, item 30 and 31, contempt case, my lord, may be closed, my lord. Mr. M.R. Khandakar, Learned Counsel for the petitioner, says that the matter can be closed as the relief has been granted to the petitioner. Who's for the other side?
In item 31, I am appearing, S.R. Burwa.
Okay, in item 31, it is Mr. Sarkar. And for item 30, no one.
No
Okay, right. On the prayer of
But
Mr.
really
M.R. Khandakar, the contempt petition stands closed.
I am appearing for a sole respondent in 31,
31, we have put your name, no?
S.R. Burwa.
I am.
Obliged.
Mayor Prevost, I'd like to mention item number 27 of today's list.
Yes.
In this matter, I'm appearing on behalf of Pollution Control Board.
Yes.
So we have to file our affidavit. At the same time, the government will also file the affidavit. We have taken the consent of the other side. So matter may be taken up after the Bihu. In the meantime, we will file our affidavit.
Who's for the other side? Okay, right. Mr. What is the name?
S. Bolwa.
Mr. S. Barwa appearing for the Pollution Control Board. And who is to file the affidavit? Who is to file the affidavit?
All the respondents, government respondents.
And Miss
G. Hazarika.
G. Hazarika.
For respondent number 1.
G. Hazarika for point number 1. And Mr. N. Goswami for
I'm for 3.
point number 3. Are granted 3 weeks time. 3 weeks time to file affidavit in the position. This is the matter of the 3 weeks.
My lord,
Yes.
my lord, I'd like to mention for 2 items. One is for motion, another is for orders. One is for substitution, another is for motion of this group
When
on 29th and 30th.
you give it to him.
Obliged.
I am paying for filing, moving in a withdrawal application tomorrow.
This is a fresh motion for Wednesday, my lord. I'm praying for listing.
What is the
One of
urgency?
the GMC authorities has sealed 3 of my rooms, my lord, whereas I have the license for all of them, my lord. And
Sealed it when?
my lord,
When?
sealed it on 21st, my lord. I filed it on Friday, my lord. Perishable goods are inside.
Ma'am, please, your lordship, I'd like to mention item number 4 of the daily list.
Yes.
Learned arguing counsel is out of station. May the matter be taken up on Friday.
Counsel has been given, your lordship.
Huh?
Counsel has been given, your lordship.
Okay, right. On the prayer for adjournment made on behalf of Mr.
Miss H. Jane.
Miss H.
Jane.
He's not there. Name is not there. There's no Jane in the pause list.
On behalf of
On behalf of N. Havelia.
On the prayer for adjournment made on behalf of Miss N. Havelia, this is the matter next week. The next.
Obliged.
deeply.
Please, your lordship. Lordship, I'm praying for listing of one writ petition in the admission column, lordship. If possible, this Thursday, my lord.
No. Give it there.
Fourth, lordship, fourth. Next Tuesday, my lord, next week.
When was it last listed?
It was last on 23rd of January, my lord. It was supposed to be listed after 2 weeks, but then it got listed.
Okay.
And similar prayer for another identical writ petition, my lord. Matter pertains to same non-payment of contractual dues, my lord. Similar matter. On 4th, my lord.
Okay.
Obliged.
Wait, please, your lordship, I beg to mention item numbers 39 and 40. My
Yes.
senior, Mr. P. Mohonto, is unwell, your lordship. The matters may be urgent for a week.
On the prayer for adjournment on behalf made on behalf of Mr. P. Mohonto. 39 is a review.
Yes, your lordship. We have taken consent, your lordship.
On the prayer for adjournment made on behalf of Mr. P. Mohanta, who is reportedly unwell. This is the matter after a week.
your pleasure.
May it please the lordship, lordship few cases to be listed for motion column, lordship. Lordship contempt matter. Lordship, otherwise the writ petition is pending before this honorable court and interim order protecting the interest of the petitioner is there, lordship. In spite of the interim order, my society has been dissolved, my lord. That is why we have filed the contempt petition, lordship. Can it be day after tomorrow, my lord?
When was it filed?
It was filed on 24th, my lord.
When was it dissolved?
On 18th, my lord. But the dissolved order is
18th of which month?
18th of March, but order is produced, given to us on 22nd, my lord.
Now what is to be done? Friday. Friday.
Oblige, your lordship.
May please lordship. With the consent of other, I left to mention item number 18 of today's list, lordship.
Yes.
I am for a petitioner, lordship. We need some reply to the affidavit filed by the government.
No. You wait, madam, you wait.
Please, Lordship. Lordship, I beg to mention item number 41, my lord. It's a review petition, my lord. I am appearing for a review petition. My senior, Mr. Chamaria, gets some personal difficulties today, my lord. I have taken the concern, my lord. Otherwise, it's there. No, next week, my lord. Any date.
All the prayer for adjournment made on behalf of Mr. S. Tamaria, who is reportedly having some personal difficulty. This is the matter in the next.
May I please, I beg to mention for listing on admission matter, settlement of that matter. Only 3 months is remaining, my lord.
Nothing will happen.
My lord, the petitioner is the highest bidder, my lord, but his.
When
settlement
did
was
you
not
file the,
considered.
when did you file the petition?
It is a admission matter, my lord.
When did you file the writ petition?
The writ petition filed, my lord, February, my lord,
February of
2023.
23.
Yes.
Next week, Monday.
Friday, my lord,
No, Monday.
this Friday.
Monday.
May I please the lordship. Lordship, item number 34, which is a contempt matter, the matter may be closed, your lordship.
Huh?
Item number 34, your lordship. It's,
34.
yes, your lordship.
What do you want?
The matter may be closed, your lordship, as it's no longer pressed.
Okay, Mr. D. Khan,
Yes, lord.
learned counsel for the petitioner submits that the contempt petition can be closed as the relief has been granted,
The matter is no longer pressed, your lordship.
as the matter is no longer pressed by him. Good, sir. Prayer of the petitioner's counsel. Who's appearing for the other side?
I am sorry.
Mr.
R.R. Gogoi.
R.R. Gogoi appears for the respondent. The prayer of the petitioner's counsel is allowed. Contempt petition stands closed as not pressed.
May I please, your lordship, I beg to mention item number 32 and 33, lordship, with regard to that review petition of Ujjwal Brahmaputra Ashok, lordship. Here in the contempt, lordship, whether the petitioner has received all amount, that instruction have to take, lordship, on Friday or Monday, lordship.
Who is the petitioner?
Mr. R. Das, I informed him telephonically.
You have already informed. That same Brahmaputra.
Yes, lordship.
Okay, Mr.
B. Chaudhary.
B. Chaudhary, learned counsel for the review petitioner, submits that he would like to obtain instructions as to whether the liability payable to the petitioner, to the writ petitioner has been paid or not. List the matter on Friday. 32, 33.
May please your lordship. Lordship, I beg to mention item number 7 for adjournment, my lord. I'm appearing on behalf of Mr. P. Talukdar, my lord. Kindly the matter will be adjourned.
No.
There are
Wait.
certain difficulties.
No,
my
no,
lord,
no.
today.
Next.
Obliged.
May I please the lordship. Lordship, I pray for listing of a writ petition in fresh motion.
When?
Can it be on Wednesday, lordship?
Friday?
Can it be on Wednesday, lordship?
What is the
There some
matter about?
urgency. The matter is the petitioners are Gaon Panchayat Samavai Samiti. They were entrusted with the work of lifting of footprints from this NFSA Act, under the NFSA Act. But the Deputy Commissioner has issued a fresh NID, and tomorrow is the date for submission of a bid.
If a submission of bid is tomorrow,
Yes.
then what happens?
The day after tomorrow, the technical bid will be open. Lordship. Therefore, there is some urgency in the matter.
What is
May I please, the lord. I beg to mention item number 17, lordship.
17?
Yes, lord.
Yes.
I am for the respondent. In this case, I will file affidavit, lordship.
Huh?
In this case, I will file affidavit.
Who will file?
Respond number 12. I will respond.
Okay, Mr.
PP Phukan.
Have you taken the consent of
Yes.
the other side?
Yeah.
Mr. P.P. Phukan, learned counsel for the respondent number 12. Submit that he will be filing affidavit in the position within
1 week.
a week. So he also submits that he has taken the consent of the other side. This is the matter after review.
Obliged, Lordship.
Okay, Lordship. Lordship, I beg to mention item number 1. Lordship, as the matter is infrastructure, that was election matter, Lordship. The matter may be closed, Lordship. Item number 1.
Item 1. Mr.
MH Shakya.
M.A. Shaikia, learned counsel for the petition, appraised that the matter may be closed as it has become infructuous.
Lordship.
Who appears for the other side?
I put a 12 full.
Mr. N. Goswami appears for point number
12 full.
2 and 4. On the prayer of Mr. M.A. Shaikia, the writ petition stands closed as infructuous.
May it please your lordship, I am praying for listing one repetition on Wednesday manner for withdrawal.
Your Lordship, this matter may be listed for motion on 29(3).
What is the matter about?
Matter is settlement of fishery.
Is it a new matter?
Yes, fresh.
Fresh matter? What happened? What is your grievance?
It's because for motion, Your Lordship.
Friday.
Yeah, please, Lordship. But just with the consent of the other side, my lord, I beg to mention item number 3, my lord.
Yeah?
Well, kindly adjourn for 2 weeks, my lord.
Why?
No, the argument.
You wait, we'll see. You wait.
My lord,
You wait.
my lord.
My lord, I beg to item number once again, Lordship. One of our junior colleague mentioned that item, Lordship. Item number 18, Lordship. In this case, Lordship, J. Roy is appearing, but he is out of station. He informed me, Lordship. So we need time to file the affidavit also, Lordship.
No, you wait. You wait.
Yeah, please, your lordship. Later matter will come for admission in the month of April, matter after vacation, matter regarding non-payment of contractual amount.
Senior counsel is on maternity transfer.
Yes.
Lordship, as per my last instruction, Lordship received the amount that has been placed before the government for necessary approval. Whether it has been approved or disbursed, Lordship, that instruction I don't know that.
That is the instruction you're supposed to get.
Lordship, it has come. Lordship may take it up on Friday. Lordship.
You see, today is what date?
27, Lordship.
Friday will be 31st, the last date. Now is the right time. There's the right time to give all the money because financially are closing. You need
Lordship,
to
but
spend.
the bill was received late. Thereafter, it was forwarded to
Maybe,
the
but then once you cross this month, you will not have money.
Lordship. Lordship may take it up on Thursday. Then Lordship, I will try to get the instruction whether it has been approved or what has happened. Lordship.
Yes, okay, right. Yes, anything to say? Mr. B. Chaudhary, learned Standing Council Agriculture Department submits that. He will obtain instructions. That was also the last. You see, this was. Wait.
A very long time. Lordship.
This was in November 2021. This information was supposed to be known by you. Now
Lordship, it
this
has-
more than a year has passed.
Lordship, I have to admit it has come after a long time, Lordship. That was I couldn't get it. Lordship may take it up on Thursday. I will have it.
What about sir?
Mr. B. Chaudhary, Learned Standing Council, Agriculture Department submits that he will obtain instructions.
With regard to whether approval has been given for payment of the bill amounting to rupees 15,48,000 to the petitioner for setting up a bundle. list the matter on 33. Or why not day after tomorrow? Or tomorrow? Why not tomorrow? You take information today.
Lordship, let it be day after tomorrow, I'll try.
Okay, Wednesday, 29.
That is a lot. Lordship, I mentioned this matter, my lord, my senior, my lord, Mr. AJ.
You want you see, what do you want out here?
My lord, I have only that much of instruction, my lord, that on earlier occasion, my lord, the petitioner before a lordship,
Huh?
on earlier dates, my lord, the petitioner before a lordship has freezed for some time for reply on the affidavit.
No, no.
That
On the
was-
last date you were absent,
My lord, then on.
and then you had asked for seeking time to file reply on December 2021.
My lord, we have already.
Now it
filed,
is 2023. You have not filed. No need. You don't want to file. We don't file. You can go to division bench.
My
That is
lord,
not
we
a
have
problem.
already filed, my lord.
Huh?
We have already filed.
You have already filed
My lord.
a reply affidavit.
My lord.
Then what is the problem?
My lord, that is not in record, my lord.
No, sorry, record does not say that.
My lord, with the affidavit in reply, we have.
Have you
some
given a
sec-
copy to the other side? They've given you a copy. Then what do? You adjourn the matter? Or what is that?
My lord, only for 2 weeks, my lord.
If it is adjourned, my lord, may come up after due vacation.
No, what do you want out here? You want the arbitration to take place. What do you want?
My lord, it was instructed me, my lord, to that the affidavit reply has been filed, my lord, and for a short adjournment, my lord. My lord, the arguing counsel, my lord, age and he is from Calcutta, my lord.
Okay, right. Adjournment prayer has been made on behalf of
AJ, my lord.
Mr. AJ, learned counsel for the petitioner. Yes, sir. Mr.
DJ Halle.
DJ Senso appearing on behalf of Mr. AJ submits that affidavit in reply has been filed. Mr. B. Goswami, additional AG appearing for the state, submits that he has received a copy of the affidavit in reply. Gustav, however, the same is not on record. Registry to place the same on record. List the matter after the vacation.
I'm obliged, my lord.
Okay, just one more thing. One of the questions that has to be answered is Mr. Goswami, is it there? Is there any arbitration clause out there in that item 3? Is there any arbitration clause?
Today, in fact, I have also not come prepared, my lord.
Okay, anyway, right. One of the parties would have to make submissions as to whether there is any arbitration clause between the parties. Then item 5.
Lordship, on previous many
None
occasions, the
appear.
petitioner has been absenting. So it seems they don't have a case. It's a premature case.
Why?
Only on the presumption they have come before the court saying that the widening would take away their land.
So there has been no widening as such.
No widening.
No. Gustav, right. No one appears for the petitioner on fault. Gustav. It is also seen that no one had appeared on the last date also. Gustav. Mr.
As Burwa,
S. Barwa appears for the
government, state government.
state government. State government who? And madam appears also for state government.
He is for the PWD.
For the
PWD.
PWD is what? Central government or what? Here for which? Mr. R. Barwa appears
As
for?
Burwa.
S. Barwa appears for?
5 and 6.
5 and 6. And Miss
S. Sarma for
1, 2, 3.
4.
Miss S. Sharma for 1, 2, 3, and 4. Stop. The counsel for the respondent submit that the writ petition is premature, as there has been no road widening and no award has been made.
In fact, they are saying that the circle officer hasn't issued any notice before widening. So as such, from our records, we don't have, because.
And no award has been
Yes,
issued.
no award.
No award has been issued. Full stop. They also submit that they also submit that as per the averment made in the writ petition, the circle officer has not issued any notification for acquisition of lands for widening of road. Full stop. Full stop. On considering the fact that the petitioner has not appeared on the last date.
Several occasions.
Huh?
Several occasions.
On several occasions, as can be seen from the orders passed by this court, this court is of the view that the petitioner is not interested in pursuing this petition. The writ petition is accordingly dismissed for non-prosecution. Yes.
May I please also kindly pass over for the time being?
Yes, when is your bank statement?
Yes, we have given.
You have given?
Yes.
Pass over for the time being? Where is your senior?
He's coming, my lord.
He's coming. Okay, we'll wait for it.
May I please, Lordship?
Yes, madam.
Lordship, matter is regarding illegal mutation of the land in the name of respondent number 5, Lordship.
Item. Illegal mutation of the land.
Yes,
In the name of the
Lordship.
respondent
And
number?
Number 5.
So.
Petitioner submitted representations before the Honorable DC, Lordship.
Yes.
And petitioner also filed an affidavit regarding the.
So let the DC decide. So let the DC decide.
Yes, but there is no response came from this Honorable DC. There are 3 representations, Lordship. Lordship may come to page number 20.
Yeah.
Again, there is page number 27 and page number 39. There are 3 representations before Honorable Deputy Commissioner.
And
Last one is 39, Lordship.
yes.
Also, in this matter, we can at least take our instruction or notice maybe should will come up with our application.
You see, instructions had been asked. You had been
Yes,
asked to
Lordship.
obtain instructions
Yes, Lordship.
since December 2022.
Yes, Lordship.
On 3 occasions now, this order has been, this case has been listed. You are still not taking instructions. How long will you carry on taking instructions?
2 weeks.
No. Why should we allow you? You have been given three opportunities also.
In fact, I am unaware about the previous orders because on the last occasion, the petitioner have been asked to file an additional affidavit.
Yes, filed it.
Enclosing the
Yes, filed
order
it.
of the circle. Yes.
Yes, filed it then.
So let us file an affidavit also.
Why? To what effect? You're not
what
even
is-
taking up instructions.
What is the status of the representation?
Why
of-
aren't you obtaining instructions in the first place? Why do you want to file affidavit when you are not even obeying the orders of the court to obtain instructions?
In fact, the last opportunity may be granted will come up. That is at least 2 weeks time.
Why? will issue notice.
Yes, sir.
Heard Ms.
The Angana.
D. Angana, learned counsel for the petitioner, who submits that the land belonging to the petitioner's father, late father, Shri Shukeshwar Gogoi, has been illegally mutated into the name of the respondent number 5 on the basis of the order dated 3/2/2022 passed by the circle officer. Oh, sir. Circle officer, which is in the affidavit dated 27/2/2023 submitted by the petitioner. Issue notice returnable in 4 weeks. Mr.
S. Burwa,
S. Barwa accepts notice on behalf of respondent numbers
2, 3, and 4.
2, 3, and 4. Ms. G. Hazarika appears for respondent number 1. Petitioner takes steps for service of notice upon the respondent number 5 by a registered post with AD within 2 days. This is a matter after 4 weeks.
Obliged lodge.
May I please, Lordship? Lordship, item 8 and 9 are similar actually. Both the firm, petition as a partnership firm, Lordship. The respondent has floated tender for construction of polyhouses. It's a house for agriculture purposes, for the covering of paddy fields. And the petitioners have completed the work within around, there was some delay due to some natural factors like rain, thunderstorm, but still they completed the task. And after that, the work order was completion was submitted to the respondent, but still the respondent had not released the payment. And then under clause 23 of the notice of tender, notice inviting tender, Lordship, kindly produce page number 19.
19.
Yes, Lordship.
Yes.
Lordship, under clause 23 of the notice inviting tender, the petitioner had sent notice to the respondent for according approval to the arbitrator nominated by the petitioner. But even after
Shall be finally settled at DOA, DAO.
district agricultural officer.
So,
But Lordship, the respondent had not accorded approval to the arbitrator nominated by the petitioner. Even after,
where does it say that the arbitrator has to be appointed by the petitioner?
No,
Who gives you the power to appoint the arbitrator?
Lordship, it is written in the notice inviting tender that if there is any dispute under clause 23 of the notice inviting tender, party can nominate arbitrator.
Who can, where is that? Where is that clause?
Lordship, page number 19. Clause
I've got it in front of me. Please read.
Clause 20.
Please read.
Clause 23, arbitration, any dispute or difference arising out during execution of work which cannot be amicably settled within 30 days, including considered as such by only one of the parties, shall be finally settled at DAO Kamrup of Government of Assam under the provisions of India Arbitration and Conciliation Act 1996. And the rules made thereunder amended from time to time. The decision of the arbitration shall be final and binding on both the parties.
So who gives you the power to appoint the arbitrator? Yes, madam. He wants an arbitrator to be appointed. What have you got to say to that?
Let me obtain my instruction.
You see, you've got no right. Where is the provision saying that you can appoint an arbitrator? You mean to say that there should be 3 arbitrators or 1 arbitrator? How many arbitrators should there be?
But she actually not appointed.
So you mean to say, as per the Constitution Act, you'll appoint your arbitrator, they'll appoint, then there'll be, then those 2 will appoint 1.
Yeah,
So there'll be 3 arbitrators according to you.
Lordship, petitioner had nominated one arbitrator and requested send notice to the respondent to accord approval.
And what about them? Can't they will also want to appoint an arbitrator.
They can also appoint Lordship, but to our notice, they have not accorded not a single approval. Or
Okay, right. Third, Mr.
NZ Chaudhary.
Huh?
NZ Chaudhary.
NZ Chaudhary, learned counsel for the petitioner, who submits that despite completion of the contract work by the petitioner, the payment for the same has not been cleared by the respondent. He submits that in terms of clause 23 of the general instructions to the tenderers, comma, any dispute arising out of the execution of the contract work has to be referred to arbitration under the Indian Arbitration and Conciliation Act 1996. So, though the petitioner has nominated one Shri Kamlesh Chakrabarti, you said to act as the sole arbitrator, Mr. Counsel. To act as the sole arbitrator, comma. The same has not been approved by the respondent. Next, on perusing clause 23, comma. No, this right. Clause 23 states as follows, huh? Page 19. A perusal of clause 23 does not indicate that the petitioner shall have the sole right to have to appoint the sole arbitrator. You have to change your.
They can also appoint, but they are sitting silent since.
Mr. Counsel, this is your prayer. This is your submission. You please come to page 11 of your petition.
Yes, Lordship.
Para 13, last line. What does it say? Page 11.
Lordship, from our perspective, we have nominated.
Mr. Counsel, you see, your perspective is different. What you are advocating is different. Okay. You are saying that you want him to be the sole arbitrator. Where does the provision allow that the petitioner can appoint the sole arbitrator? Where is that? What have I said? Sole arbitrator, no? Then-
A perusal of clause 23 does not indicate that the petitioner shall have the sole right to appoint the sole arbitrator.
Anyway, issue notice returnable in 4 weeks. Miss
Arbora, Lordship.
R. Bora, accept notice on behalf of
Respondent, Lordship.
all the
Only one is-
respondents.
Only one is there.
Oh.
District Agricultural Officer.
Responded only one.
Only one.
We should have made Lordship the
He is the
director.
sole respondent.
How, this is not a, this writ petition is not even against the state, it's against the private individual, correct?
Yes, Lordship.
This clause 23. Let us see your work order. Let us see your work order. You see, Mr. Counsel, this has been done by the, maybe by the district agriculture officer, but it has been done on behalf of the state government. The state government has to be made a party.
That pleases Lordship. Lordship, there may be some error on the petitions. So Lordship may kindly allow us for some time to rectify if any error takes place in the petition itself. This is humble submission for your Lordship.
What you do is, I'll tell you the easy way out, because you'll have to make state a party, you'll have to probably make the director a party, then you'll have to probably make this person a party, and then maybe change your pleadings so as not to ask for sole arbitration, sole arbitrator.
Yes, Lordship.
Okay?
Lordship,
Because
we just propose a name for the arbitrator, Lordship. Under clause 3 of the notice.
you have used the word sole arbitrator, Mr.
Lordship,
Counsel.
Lordship, that may be rectified, Lordship.
So just listen to what we are saying.
Yes, Lordship.
So the thing is, best you withdraw this, make a corrected, because by the time you make amendment, everything, you'll take around another 2-3 months will go, minimum.
Lordship, kindly provide us some time. Lordship, let us take the instructions from the party also.
Whatever. Okay, then you also write. On perusal of, let's say issue notice. On perusal of the writ petition, it is found that the petitioner has not made the state government a party, but has only made the district agriculture officer as the sole respondent. On the prayer of the petitioner, list the matter after 2 months. Best is you withdraw and file a fresh. That's the easiest way. I don't know why you're wasting time. Anyway, both the matters.
Deeply obliged.
Accordingly, it appears that the writ petition does not appear to be maintainable at this stage. This is a matter after 2 months.
May I please, my lord, page 46, Lordship will find the order passed by this honorable court.
Item?
Page 46, item 10, my lord. Page 46, my lord. And Lord, the operative part at page 49.
Just a
there are
minute,
five.
just a minute. Item 10.
10, no?
Okay, right. Heard Mr. M.U. Mondal, learned counsel for the petitioner, who submits that despite the respondent being directed to dispose of the petitioner's representation dated 10/11/2019, by order dated 19/10/22, passed in WPC 6578/2022. The same has not been done till date. However, even though the order was furnished to the respondent on 7/11/22. Issue notice returnable in 4 weeks. Petitioner will take steps for service of notice upon the respondent by a registered post with AD within 2 days. This is the matter of support.
Developed.
May I please ask? This matter relates to a tower line compensation. A transmission line passing through a plot of land belonging to the petitioner, that it was constructed under Assam Grid Corporation Limited. In this regard, joint survey report was conducted. On the basis of that, one bill was prepared in the name of the petitioner, and accordingly, a check was issued in the name of the petitioner. But from the revenue department is denying that no, you are not entitled, as because the public complaint against him.
Why?
Public complaint. And AGCL here filed their affidavit in opposition. And they are also admitted that 1% land is belong to the petitioner. So there is no dispute. But revenue department, why denying that?
Yes. Who is appearing for the revenue department?
Here, statute is the Electricity Act 2003. And in exercise of power, the Electricity Act 2003, this compensation was awarded to the petitioner. This is the case.
Now, who is appearing for the revenue? Yes, madam, what is this? Why you return back the check?
Page 50 is the valid date.
You were supposed to obtain instructions on the last date. I think you call this person, let him come personally before this court.
6 and, Lordship, on the last occasion, respondent number 6 and 7 took time to file affidavit. Lordship.
No, you see, maybe. But then, you see, this is already a month has gone. This is all the check has been issued.
Yes, sir.
Now, why did you return it? If you have taken a decision to return it, shows that already a decision is there for return of the check. So that decision has to be brought to the notice of the court. Let him appear in person. Let him appear in person.
Lordship, grant me 2 weeks time to.
No. We are granting you till Monday. Let him come on Monday.
An extra 3.
This is not the way.
Lordship, next week, fix next week, Lordship. We'll come
Monday.
to, instruction, Lordship.
Okay, right. Heard, Mr.
Care of Manmal.
K. Raman, learned counsel for the petitioner. Miss G. Hazarika appears for
No, Lordship, respondent number 1.
respondent number 1. Who appears for 6 and 7? Yes, you are the one.
Yes, Lordship, I am for only 1, Lordship.
Miss G. Hazarika appears for respondent number 1. Mr.
As Burwa for 6 and 7.
and Mr. S. Barwa appear for respondent number 6 and 7. You tell them to appear next Monday, both of them.
3, 4, 5.
6 and 7. Huh?
I'm waiting for 3, 4.
Mr.
That's good.
S. Kotoki appears for respondents number
3, 4.
3,
4, 5.
3, 4, and 5.
Lordship, my humble prayer. At least I will take my personal responsibility to come up with the instruction by Monday. At least that personal appearance may not be given at the moment. My humble request.
Then we'll fix it on Friday.
Yes.
We'll fix it this Friday.
Yes.
And if you don't bring instructions on Friday, we'll tell them to.
Definitely.
Okay, right. The petitioner is agreed by non-release of the compensation amount which had been made by way of a check by the AEGCL. First up. The said check had been returned by the respondent number 7 on the purported ground that there was a public complaint.
Yes, sir.
First up. Next para. This court by order dated 20/02/2023 had directed that the respondent number 7 should file an affidavit explaining the reason for return of the checks in favor of the petitioner. This court also directed the learned junior government advocate, Mr. R. Talukdar, to obtain instructions from the respondents number 6 and 7. However, neither is there any instructions forthcoming, nor has any affidavit been filed. Mr.
As Burwa.
S. Barwa, appearing for respondent number 6 and 7, submits that he will definitely obtain instructions by 31/3 as to why the check was returned by the respondent number 7. Accordingly, list this matter on 31/3.
Blessed.
31/3. First up, in the event of any instructions being forthcoming, the personal appearance of the respondent number 6 and 7 may be called for.
May I please, your lordship? In this case, the petitioners are the landholders of some plot of land with different dark numbers and patta numbers. Their lands were acquired by the Water Resource Department for construction of a dike in the
Of a dike.
dike on both left and right bank of Kapili River. Your lordship. And the compensation has not been paid yet, your lordship.
And what is the stand of the Water Resource Department?
Your lordship, they have filed additional affidavit in opposition, and then they denied the fact that they acquired any land. We have filed rejoinder, your lordship.
Now, so if there is a dispute, what to do?
Your lordship, please see page number 45 and 46 of this petition, your lordship.
45 and 46.
There is the one of the petitioner number one applied make an RTI, and the reply was there in page number 45 and 46. In this RTI reply, the reply was made by the executive engineer, Moriga Water Resource Department, Water Resource Division. And in this reply,
No, compensation is going to be paid, but how do we know that your land has been involved? Where is the proof?
your lordship, the down numbers and pata numbers are
Huh?
given, and one certificate was issued by the circle office of the.
Is it a part of the record?
Yes. We
Which
have filed
page? Which page?
additional- We have filed additional affidavit.
You have filed additional affidavit.
Additional affidavit.
Yes. Which para?
May I read the vernacular, your lordship?
Unfortunately, I have got no. I will have no idea what you'll be reading.
Your lordship,
Your land is covered by DAG number 25.
yes, your lordship.
Miyadi Pata 76.
Yes, your lordship.
Yes, what to do, Mr. Goswami?
My lord, this is a scheme, my lord, executed for raising and strengthening the the scheme which was prepared earlier, which was executed earlier, my lord, not the new scheme, my lord. Maybe this land is within the area of the scheme, my lord. This may be, but no land is required, my lord, for the purpose of execution of the scheme, my lord. This is execution. This scheme is executed only to raise the embankment.
It doesn't really affect the land. It's protecting it, in fact.
Nothing, my lord. Even if the embankment was already there, it was raised and strengthened. That is why, my lord, no land acquisition procedure was there.
Yes, madam.
Your lordship, if you see the page, come to the page number 46, the Water Resource Department, the reply of RTI filed by the Water Resource Department Executive Engineer, he clearly mentioned that the estimated value of compensation is.
Estimate for the raising the embankment. That is the cost. So is this? You see? No. You see, madam, one thing. This making the dike or whatever. How has it affected your land?
Your lordship, it is making a dike along with anti-erosion measures.
Huh?
It is not only enhancement of anti-erosion measures of an existing dike. It is the construction of a dike along with anti-erosion measures, your lordship.
Anti-erosion?
Anti-erosion measures, but along with construction of a
How so? How does it affect you? It's protecting your land, in fact.
No, your lordship, this is there was construction of a dike along with anti-erosion measures in some places of an existing dike. There was new construction of a dike, your lordship.
Oh, what is the dike? Tell me, what is the dike?
Dike means a dike on the bank of a river to prevent soil erosion and to prevent.
Now, how it's protecting your land. How does it affect you? What is the loss cost to you?
Your lordship, they acquired our land for construction of new dike. Your lordship, there was a dike in some places. A dike is quite lengthy in length.
Where is the acquisition of other people's lands for construction of a dike?
Your lordship, they have, there is Zamabandis, but they cannot, they now acquire the such. I mean, in the Zamabandis, their land and Dag number and Pata numbers are mentioned.
No, no, madam. Do you understand what I'm saying? Show me instances where compensation has been given to landowners on whose lands these dikes have been made, or where the soil erosion preventive measures have been undertaken.
Your lordship, instructions may be taken from the petitioners. Further instructions. It may be given for taking further instructions.
Yes, can anybody tell me this? Your colleague wants to know whether compensation is payable for construction of a dike, which is for preventing soil erosion. Is it being done? Can anyone in the bar just tell me? Though they're all quiet. Supposing that dike was not constructed, then then there's a possibility that the flood waters can take away your land. Then what would happen? So maybe what the government is doing is in fact protecting your land.
Protecting our land, your lordship.
Then, and you want payment of money for that also, for protecting your land.
Your lordship, government generally gives compensation. Government generally provides compensation for.
Give me some examples. Show me some examples.
Your lordship, some time may be given
Huh?
for, if that may be given for taking instructions or putting some similar examples.
Okay, right. What's your name?
As said Hayat.
Miss SZ Higher Learned Counsel for the petitioners is granted time to obtain instructions as to whether persons on whose land dikes have been constructed for the purpose of prevention of soil erosion are being given compensation by the government.
And also for the purpose of strengthening and raising the embankment, whether the land was acquired. Because that is the core issue.
First of all, she will also obtain instructions as to whether compensation has been given to other persons for strengthening and raising the embankment.
Embankment, the present scheme, under the present scheme.
With regard to the present scheme that has been advocated in the writ petition. When do you want, madam? After?
After Bihu,
This is the matter after Bihu. You just think about it, madam. If they hadn't done it, your land might go.
Yes, your lordship.
And but you see, when they make an embankment or a dike or whatever, how does it affect your land? I mean, they're protecting your land. Yes, what is to be done? Mediation still going on.
Mediation is.
So we adjourn the matter.
Mediation report is there, your lordship, it was unsuccessful. So
Oh, mediation report is there.
Yes, yes.
Okay. Mediation report of 17-1.
No, no, Lordship. There was a new one, subsequent also, on later date.
Huh?
Handwritten note from the.
Flag Z. Okay. So mediation unsuccessful. So yes, so what is to be done now?
Or should we take it up for disposal?
Okay. Right. Causes for the parties are present. They submit that the mediation, the attempt at mediation was unsuccessful. Accordingly, on the prayer of the parties, list the matter after the BU. After the BU.
The petitioner is, your lordship, the stamp vendor, your lordship, and the respondent number 2, as per impugned order dated 16/10, your lordship, annexure A, page number 11, my lord, whereby it is alleged that the petitioner has sold 2 numbers of stamp paper, your lordship, at higher price, my lord, which is not true, your lordship. On 14/9/21, your lordship, hearing has been conducted by the respondent number 4, whereby the petitioner has submitted the written statement, my lord, where clearly states that the petitioner has sold those 2 stamp paper to one Aftabuddin, your lordship. And after that, Aftabuddin Loshkar has sold the stamp paper at higher price, my lord. So stamp vending is the only livelihood, my lord, for the petitioner.
But what can we do? This is a question of fact.
The case of the petitioner may be considered, my lord, with some penalty or fines, my lord, but the cancellation of the license is.
Yes.
An admission on the part of the petitioner that he has transferred those stamp papers to some other persons who are not authorized to sell it, and those people are selling it at a higher price, for which the inquiry has been called for, and from the inquiry, from all the records that has been brought across, it has been found that those were issued by the office only for selling by the petitioner, whereas he has transferred it to the other persons who are selling it at higher cost, and for which notice has been caused to them. He has been asked and he has admitted doing that fault, and that is a violation, outright violation of his agreement, whereby that license agreement, he has violated it. So there is no denying the fact, and there is no lapses on the part of the government as regard the proceeding that has been taken place.
Have you filed a representation to the Deputy Commissioner with regard to this order? Impugned order?
Yes, sir, lord.
Where is that?
Actually, your lordship, unfortunately, annexures are not there in my petition, my lord.
Sorry. We cannot help it. If it's not there, it's not there.
In fact, in that reply to that notice, even though it is in vernacular Bengali, I couldn't translate. He has admitted that he has done that mistake. The second page.
So you could not understand this.
I can understand.
You can understand. And you expect me to understand. What does it say? Give me an idea.
আমি প্রার্থী একজন শিক্ষিত বেকার হিসাবে স্টাম্প ভেন্ডরের কাজ করিয়া জীবিকা নির্বাহ করিয়েছি। কিছুদিন পূর্বে আমার এক সহকর্মী আফতাবউদ্দিন লস্কর আহার নিজা প্রয়োজনে আমার নিকট হয়েতে একটি, so he told that because of the closeness with Aftabuddin Laskar, he has transferred those stamp papers for to be sold by Aftabuddin. This he ought not to have done.
So this is he has written to the SDO, Sadar, Hailakandi.
Yes.
What is that?
Nothing remains.
You see, Mr. Council, there is one thing called your aggrieved person. You have got to show this court that some right of yours has been violated. What right of yours is violated?
No, your lordship.
Now you want the illegality to be allowed, to be condoned. Let the concerned commissioner do it. He is the appointing authority.
No, your lordship, the person who has purchased from me, your lordship, he has purchased as purchaser, your lordship.
No. In fact, that also we have made it clear. While someone is being sold, the sign has to be on the back side of the stamp paper. That is also.
That is not there.
Yes.
That is the only.
There is no record to prove it.
Fault, your lordship.
Okay, right. Heard Mr.
R that, your lordship.
R.
Dash.
Dash, learned counsel for the petitioner. Also heard Mr.
S. Bulwa.
S. Barwa, learned counsel for the
Learned government advocate. Respondent number 2 and 4.
2 and 4, and Miss G. Hazarika for respondent number 1. The petitioner's case is that the district administration of Hailakandi granted license to the petitioner in August 2014 as a stamp vendor, allowing him to sell court fee and non-judicial stamp papers in the compound of the Deputy Commissioner's office, Deputy Commissioner's office at Hailakandi. However, the Deputy Commissioner Hailakandi, by order dated 16/10/2021, cancelled the license issued under number HRC /2013/130-A, capital A. Issued against the petitioner, allowing him to sell court fee and non-judicial stamp paper. The petitioner's counsel submits that the cancellation of the license by the Deputy Commissioner Hailakandi was made on an erroneous finding that the petitioner had sold his non-judicial stamp paper to one Mr. Aftabuddin, who have thereafter sold it at a higher price to other persons. The petitioner's counsel submits that he had sold the non-judicial stamp papers to Aftab Hussain, Aftabuddin, and the subsequent selling of the stamp papers to some other persons by Aftab Uddin, was not to the knowledge of the petitioner. He accordingly submits that the impugned order dated 16/10/2021 should be set aside. Mr. S. Barwa, learned counsel for the respondents number 2
and 3.
2 and 3. On the other hand, submits that in view of the petitioner selling the non-judicial stamp papers to, to some other persons, comma, who in turn sold the same as a stamp vendor
At higher price.
at a higher price, comma, uh, an inquiry was instituted. The inquiry instituted came to a finding that the petitioner had indulged in malpractices by transferring stamp papers to another stamp vendor without selling the same directly to genuine customers, comma, in violation of the terms and conditions of the stamp vendor license. He also submits that the petitioner did not maintain proper sale register, which was required to be done to record the buyer's name. He also submits that the petitioner in his letter dated, what is this letter dated?
14/9/21, Your Lordship.
14/9/21, made in reply to the notice dated 10/9/2021, issued by the subdivisional officer bracket S, comma, Hailakandi, has admitted to the fact that he sold the stamp vendors, the stamp papers, to Aftab Uddin.
Laskar.
No, Aftab?
Aftabuddin Laskar.
Aftab Uddin Laskar, comma, who in turn sold the same at a higher price to customers. He submits that as notice was issued to the petitioner, and he submits that as all the procedural formalities were conducted by the state respondents prior to coming to a finding that the petitioner had indulged in malpractice and cancelling his vendor, prior to cancelling his stamp vendor license, comma, there was nothing to agitate. There was nothing left. There is nothing left to agitate in the present case. So we accordingly pray that the writ petition should be dismissed. Full stop. I have heard the learned causes for the parties. Full stop. On perusal of the record, comma, it is seen that not only was the petitioner given notice of the allegations made against him, but he was also, but an inquiry had also been instituted on the alleged malpractices by various stamp vendors, including the petition. A perusal of the impugned order dated 16/10/2021 shows that the petitioner had transferred stamp papers to another stamp vendor without selling the same directly to genuine customers. Further, he did not maintain proper sale register with regard to the stamp papers sold by. The letter dated, what is that letter again? Letter dated, the one I cannot read.
14/9/21.
The letter dated 14/9/21. Is it part of the record?
In fact, it has not part of the record, but already a statement has been made in the affidavit.
Where?
As statement. That's page 5. Page 5.
Your page 5.
Yes.
Yes.
Page 5. The first paragraph, the last part of it. he was asked to submit his stock and sale register white notice numbers so and so, and only after his submission that.
Page 5 of your affidavit.
Yes, my affidavit. In
At the
fact,
first it starts as such, it has become.
as such, yes. As such, it has become clear that if your lordship goes.
Okay. So, stop. What have I said?
Later dated 14/9/2020.
No, cut that. And the respondent number 3 in para 6 of his affidavit has stated that 3 of the 4 exhibit stamp papers were actually issued to the petitioner by the treasury officer, Hailakandi, and the petitioner had transferred it to after.
After would be last.
After, it should be after, not after. You have written after. AFTER.
After. After would be.
After Uddin Laskar, as admitted by him. You have written after AFTER.
Yes.
I think you should collect. You should make correction in all everywhere. It's after. Good stuff. Yeah,
Might
good stuff.
be when after was written, the computer has taken after.
Could be.
Maybe a typographical.
As there is no counter or denial to the said averment made by the respondent number 3 in his affidavit in opposition, the said averment would have to be deemed to be an admitted fact. In view of the above reasons, this court does not find any reason to interfere with the impugned order dated 16/10/2021. It is also noticed that the petitioner has not filed any representation to the Deputy Commissioner Hailakandi with regard to the impugned order dated 16/10/2021 prior to approaching this court. As there is nothing to show that any legal right of the petitioner has been violated by the impugned order, this court does not find any ground to exercise the discretion in the present case. Of the writ petition is accordingly dismissed.
Oblige, Your Lordship.
Nothing to put on this. Yes.
But in terms of the order date 21/12, my lord, they have furnished the bank statement.
Then can be closed.
Can be closed. But my lord, only thing is that the petitioner is disputing, the petitioner is disputing 2-3, my lord, statement, my lord. We may be granted liberty if his agreed to come again. This petition may be closed down.
Raise it with those, raise it with the bank. Heard, Mr.
B. Hazari.
P. Hazarika, learned counsel for the petitioner, and Mr.
M. Sharma.
M. Sharma, learned standing counsel for the respondent. The grievance of the petitioner is that although he is willing to clear his outstanding dues payable to the bank, but in the absence of an authentic bank statement indicating the amount which is actually due from the petitioner and on the which head the petitioner is to pay, is to make the payments, comma. The petitioner is unable to make the payments. Mr. M. Sharma submits that the authentic bank statement which has been sought for by the petitioner has been furnished to the petitioner on
6/1, 6/1.
6/1/2020. Full stop. Next para. In view of the, no, next para. Mr. P. Hazarika submits that in view of the authentic bank statement being furnished to the petitioner will now make payments to the bank for its outstanding dues, subject to clarification of one or two of the entries in the
Statement given by
one or two entries in the bank statement furnished by the respondent. Full stop. He submits that the payments will be made within a period of that is required. You cannot have 10 years or 20 years.
No.
How much?
6 months.
So maybe on 2 months maximum. 6 months is too long because the loan was of 2006.
Well, in spite of repeated requests, well, that entries they are not correct. Therefore, paying for 6 months.
If it's not correct now, it won't be correct then or
Yes, sir.
how much have you accepted out of the bank statement?
Well, 2-3 entries I have deposited, they are not indicating that.
No, but how much? You just tell me, bank statement has been furnished to you. Out of that, how much are you willing to give? This cannot be a merry-go-round that you come here, then you go there, you come again.
Well,
How much? Which entry according to you is not correct?
yes, well, and bank statement is with the petitioner now. Well, only well, his grievance that
What have I said?
He submits that the payments will be made within a period of.
Within a period of 3 months.
Well,
Within a period of 3 months from today. Accordingly, the petitioner is directed to make payments to the respondent bank within a period of 3 months from today.
subject to clarification.
On the basis of the bank statement furnished by the respondents, which naturally should be clarified if required to be clarified. The petition accordingly disposed of.
Obliged. Hello.
I'll seek some accommodation because there's some corresponding rules which I could not procure today. Come after a few days.
Mr. D. Gogoi, Learned Counsel for the Forest Department, is granted
1 week.
is granted a week's time to.
Do I have some corresponding rules?
What are you filing any affidavit? No.
No, my lord. This can be without affidavit can be done.
Okay. Granted a week's time to obtain what? To obtain?
Some instructions, my lord.
Obtain instructions. This is a matter of. Oh, sorry.
Deeply obliged.
Alright, in this case, Lordship, respondent number 10 file an affidavit, Lordship. We need time, Lordship, to file a.
You don't need to file anything.
Lordship,
We don't need to file anything.
Lordship.
You don't need to file anything. It's not your right that whenever they file something, you have got to reply. What is your case?
Lordship, regarding installation of a tower, Lordship.
Yes,
at a public place.
installation of a tower.
Lordship.
Now, you don't own the tower, correct? On
We
what?
are the-
Huh?
We are the local people of that area, Lordship.
Maybe.
Lordship.
Now,
We
what-
raised the complaint before the authority also,
Ah.
that was not accepted. Lordship.
Huh.
And respondent number J is Lordship. This is Sumit Digital Infrastructure Limited, Lordship.
Yes. Yes, why don't you want it?
Lordship, in this case, Lordship, as Bhattakur is appearing, he is the person to explain all this thing. He is in another court, Lordship. That is why, Lordship, and in the meantime, we will file the reply.
No, there's no requirement of reply. Yes.
Well, this though it's been projected as a cause of public grievance, my lord, but the party which is mainly doing this is Reliance, which is a private entity, my lord.
Huh?
Reliance, my lord, Reliance Telecom.
We make
This tower is erected by Reliance Telecom, my lord. And I am for the affiliation as such, we don't have any role. But this needs to be pointed out, page 4, my lord, respondent number 5. This tower belongs to Reliance, my lord.
Reliance is there, item 5.
No, what I'm trying to point out, my lord, this is this though is a showcase as a public cause, but my lord, this entity is totally private in nature, my lord. Apart from that, these my lord, these other parties are also supervisory.
My lord, kindly fix the matter in another day, Lordship, because as Bhattakur is a lax, Lordship.
We'll wait for him. We'll wait for him. We'll tell him to come. We'll wait for him.
Lordship, in this case, we have received some instruction, Lordship. We'll file an affidavit, Lordship. We grant 3 weeks time, Lordship.
Then which item is this?
19, Lordship.
Okay, Mr. B. Chakrabarti, Learned Counsel for the, here what? CGC.
CGC, Lord.
Mr. B. Chakrabarti, CGC, submits that he has received instructions and will be filing affidavit within
3 weeks, Lord.
3 weeks. This is the matter after 3 weeks.
But you may fix a date, Lordship.
After Bihu. Yes,
My senior leg is another court. Yes.
yes, what is to be done?
Lordship, we have not received instruction, Lordship. May have been not in Lordship. His representation is pending before Deputy Commissioner, Lordship. That may be like to.
Let him come. Okay, then let him.
Lordship, password for the family. My senior counsel is on late. Court number 6.
Huh?
Court number 6.
This is with regard to educational loan.
Yes.
You're not eligible. You don't have the, where is he?
Court number 6. Lordship, court number.
Huh?
Court number 6.
Let him come. Give it to him.
Non-payment of contractors list.
Yes, what to do?
Lordship, I dispose it.
With how?
I'm sorry. Chief
Huh?
engineer will verify and pay, Lordship. And he will, as per the judgment of 2008 for JLT. Similar matter today disclosed by honorable court.
Huh?
Similar matter disclosed today, court number 50. Order is not online, thus he will disclose. In light of the judgment of Kamsel,
Percentage.
Kamsel, 2008 for GLT 1, as per the guideline of Kamsel. Dispose of the similar matter.
Show me the judgment. I don't remember.
It's not, it's not noticed.
Get it? Yes, who is this Mr. Barwa? You're Mr. Barwa.
My,
Huh?
my colleague, Lordship.
You were supposed to obtain instructions.
Yes, Lordship.
Then,
Lordship, we have written to the department.
Huh?
We have written to the department.
Then?
We yet to receive the instructions, Lordship.
Then?
Lordship may grant 1 week time. Get the instructions. Whether the amount is admitted or.
we are always granting time to you. December also we granted time.
I will promise that to judgment.
Huh?
Can you fix up 2 lakhs? I will produce that as well and present 8 plus GST.
You find out.
Lordship may give me 1 week time, Lordship. I will produce the instructions.
You see, the only thing is whether the dues are admitted or not. That's all.
Yes, sir.
We listed on Friday.
Lordship.
Mr.
SM Hassan, Lordship.
SM Hassan, Learned Counsel for the PhD department, submits that he will obtain instructions as to whether the contractual dues of the petitioner are admitted or not. This is the matter of Friday.
22 same Lordship.
2023 also
23
same
also
Friday.
same. Lordship can fix up 2 lakhs. I will produce and
Huh?
fix up.
No. Let him obtain instructions whether they admitted or not.
Similar to the dispute of in his presence in the court number 12. Same issue.
Maybe, but these are dues of which date? Dues of which year?
2012 had it. Same.
12, 13. And read petition filed when?
2022.
22, after 10 years.
Wait.
You get the-
Lordship, I'll get the instructions.
What? Yes, who's appearing?
Right, please, Your Lordship. As per last order, respondent supposed to file their affidavit, Your Lordship. But they have not
Please, Your
filed.
Lordship. I am appearing on behalf of Mr. H.K. Daswala, High Court Standing Counsel. We have sent our affidavit in opposition to the registry for vetting. As it takes some time, similar I pray for 3 weeks time, perhaps by the time we'll get it vetted, we can file it.
Mister? Your correspondent number?
Respondent number 2, my lord.
Two only?
No, my lord. No. 2, 3, and 4, my lord.
What about you? Are you filing anything, Mr.
No,
Prasad?
it's a bit.
Okay, Mr. H.K. Das.
Yes, sir.
Also for the respondents number 2 to 4 is granted
3 weeks time, my lord.
3
I've
weeks
got the
time to
instruction.
file affidavit in opposition. This is a matter of dispute.
Keep your pleasure.
Highly.
Make with your loss. My lord, by order dated 18/1, my lord, notice was issued. And they are supposed to file affidavit.
I am for respondent number 1 and 2, my lord. We did further 2
Notice
weeks
was also
time.
in respect to the
Affidavit.
intent
Huh?
prayer. Notice was also issued in respect to the intent prayer. For a
Already started work.
Yes, my lord.
Mr.
S. Botago, my lord.
S. Bar Thakur, Learned Counsel for the respondent number
1 and 2, my lord.
1 and 2, and Mr.
My lord, my age of them appearing for respondent number 3, man. Private respondent number 3.
and Mr. H. Chowdhury appearing for respondent number 3 are granted
After Bihu, my lord.
granted 3 weeks time to file granted 2 weeks time.
Not 3 weeks, my lord.
3 weeks time to file affidavit in opposition.
My lord,
This is the
I
matter.
pray for a date.
Give a date after vacation.
In this case, if your lordship can take it up day after tomorrow, your lordship.
Why? Take it up
Your
now.
lordship, in fact, your lordship, since we have thought about filing an affidavit in reply,
And
No, no,
I did
it's not
reply.
required. What is the requirement of reply?
Your Lordship, that's filed by the respondent number 10, Your Lordship.
How does it's just on an issue?
Basically, Your Lordship,
Doesn't make any change.
what we pray, Your Lordship, pray is, Your Lordship, that there is a circular, Your Lordship, guideline
Yes.
issued by that is at page 20, Your Lordship.
Page
20. That guideline has been issued by the Commissioner and Secretary of Assam Information Technology Department relating to the construction of towers, Your Lordship, installation of towers, Your Lordship. And that has been, Your Lordship, subsequent to an apex court judgment, Your Lordship, and our High Court order is also there, Your Lordship, where if Your Lordship takes up, Your Lordship, page 24, clause 17, disposal of public grievance.
Yes.
Our case is that, Your Lordship, that has not been followed, Your Lordship, while considering the issue.
So it can always be done now.
Lordship, our prayer at the relevant point of time is also was there that our appeal is pending. That should be considered as per the guideline, Your Lordship. But at the relevant point of time on this honorable court, Your Lordship, direct them to bring instruction. Whether, Your Lordship, they have passed any order or not, Your Lordship, in this. They did not, Your Lordship. Thereafter, notice was issued. Your Lordship, that's it. There is no interim order also, Your Lordship. Now, Your Lordship, a disposal of public grievance, Your Lordship, and that is precisely the reason, Your Lordship, why we came before this honorable court, Your Lordship, that this has not been followed, Your Lordship, while considering the issue, Your Lordship. At one point of time, there was a direction by the GMD authorities, Your Lordship, that there is violation, Your Lordship. If Your Lordship comes to page 55 of my petition, Your Lordship, 55, Your Lordship.
Yes.
This is in the year 2016 itself. This is an observation made by the GMD authority, Your Lordship, to the Deputy Commissioner, Your Lordship. And that is on the basis of, Your Lordship, the inquisition made by the Deputy Commissioner, Your Lordship. It says authority issued so cause notice against the unauthorized mobile tower number so and so against Sulaiman Ali Khan has submitted a reply without documentary evidence like NOC of mobile tower, etc., etc. Now, bringing in this facts, Your Lordship, we pointed out that ultimately, Your Lordship, it is for them, Your Lordship, the authorities to concern. They only require to see whether, Your Lordship, this grievance that we have been raising, Your Lordship, that has to be looked into in terms of this guideline. This is our case, Your Lordship, nothing more than that.
So let it be looked into.
Lordship, that can be, Your Lordship. Okay, in this regard, I want to say something, Lordship. Respondent number 1 of the file on affidavit, Lordship. In this affidavit, Lordship, we have made one statement, Lordship, that they have some alternative remedy, Lordship. They can file appeal before a district telecom authority, Kamrup, Lordship.
The same thing.
That's what I am saying.
Only one thing is, I think respondent number 10 has said that the DC himself has given permission.
Lordship. DC has given permission, Your Lordship, and without.
But that doesn't mean that he cannot look into this grievance. So if both of you all agree, then we can say that the DTC look and then they can file an appeal.
Lordship.
Where is your complaint to the DTC?
Lordship will kindly get it, Your Lordship. Our first complaint, Your Lordship. This is page 35, Your Lordship. This is to the chairman, GMD, Your Lordship. And then, Your Lordship, will.
When was the tower constructed?
It was, Your Lordship, initially it started, Your Lordship, in the year 2016. Then we made a complaint, Your Lordship, before the circle officer, and circle officer forwarded that to the additional deputy commissioner, that is the office of the deputy commissioner. Then
just a minute. Who is this Minu Akatara? Is she a party here?
Lordship, no, only one has come, Your Lordship, out of them, Your Lordship. There are, Your Lordship, more than 32 persons, Your Lordship, who come.
No, out here there is only one petitioner,
Yes,
Kanak Lata Bora.
Yes, Lordship.
Now, Kanak Lata Bora, this page 35 is not by Kanak Lata Bora. We do not know who has written this letter.
These are your lordship by the residents, your lordship.
No, we do not know. We do not.
And in fact,
She's not a party.
I have made a statement that we have been authorized by all others, your lordship, to file this case. Your lordship.
No, that cannot be.
Even then, your lordship, I can file a press appeal, your lordship, before the authority. That can your lordship always give me that liberty, your lordship, and they will go by this, your lordship, guideline they themselves, the government has issued, your lordship. And in fact, your lordship, this guideline has been considered by in PIL 88 of 2013, your lordship. This is based on the, your lordship, guideline, advisory guideline issued by the Department of Telecommunication of Union of India.
Yes, please query for point number 10.
He is not there, your lordship. We have, in fact, we have talked to them.
Huh?
The council representing his out of station.
Who is he?
Name is also not shown.
Who is he?
J. Roy, senior advocate.
Your Lordship, my senior Mr. J. Roy appears for respondent number 10. He's out of town due to some personal difficulties today, Your Lordship.
So what does he want?
I thought he was called.
Huh?
I thought the respondent was called.
We had also informed them that we will take time. That's why we had also informed them that we will take time to file and reply to their evidence.
There is no requirement of filing a
Lordship,
reply. Why do you
Lordship
want to
can
file a
dispose it
reply
of.
to this issue?
I leave it to your lordship. We don't have otherwise anything against the installation of tower, but your lordship.
But is this guidelines applicable after the tower has been commissioned or prior to the commissioning of the tower?
If your lordship kindly come to that guideline, if there the language is like this, your lordship. If there is any individual or public grievance related to establishment or operation of a mobile tower, that means your lordship, even after your lordship, it becomes operational, your lordship, one can.
Where is your complaint?
Your lordship, our complaint is your lordship initially in the year 2015.
No, not that. That is not your complaint. That person is not a party. We do not know.
Specifically, your lordship, there are complaints, but that is not by me, your lordship, but other residents. Even otherwise, your lordship, since at this stage also I can file a.
You can file a fake one.
That's.
Heard Mr. S. Bhattakur, counsel for the petitioner. Also heard Mr. N. Goswami, counsel for
1, 3, and 4.
1, 3, and 4. Mr. S. Barwa for
2.
2. Mr. Huh? Mr. D. Gogoi for point number 8. Then Mr. S. Sharma. No, Mr.
Your Lordship, Miss Enat.
Miss Enat.
On behalf of Mr. J. Roy. respondent
On
number
behalf
10.
of Mr. J. Roy, counsel for the respondent number 10. And Mr. S. Bora for
6 and 7.
respondent number 6 and 10. The grievance of the petitioner is that a mobile tower has been illegally and unauthorizedly installed by the respondent number 9 on the second floor of his residential building in Noonmati locality under Guwahati Municipal Corporation. The petitioner's counsel submits that the illegal and then that the installation of the mobile tower has been made without following the inverted commas, the guidelines for issuance of clearance and permit for installation of mobile towers in Assam and disposal of public grievance. In this regard, inverted commas close. Issued by the Commissioner Secretary to the Government of Assam, Information Technology Department. The petitioner's counsel submits that though various residents of Noonmati locality had made complaints against the illegal and unauthorized installation of the mobile tower. No decision has been taken by the District Telecom Committee bracket DTC headed by the chaired by the Deputy Commissioner. Kamrup M.
Metro.
Kamrup bracket M. He submits that the writ petition can be disposed of if a direction is issued to the Deputy Commissioner bracket Kamrup M. If a decision is taken on the grievance of the petitioner with regard to the illegal and unauthorized installation of a mobile tower in the premise of the respondent number 9. Madam, you were saying something in the morning. Did you ask for adjournment or something? No, no. So we can dispose of the matter. According to you, you've got no instructions from your senior.
No, Your Lordship.
Okay. The learned counsels for the respondents submit that they've got no objection. Any objection? Any objection? If let him file a fresh application to the DC. The learned counsels for the respondents submit that they have no objection if the DTC takes a decision on the petitioner's grievance, provided the petitioner submits a fresh representation to the DTC chaired by the Deputy Commissioner Kamrupan. I have heard the learned causes for the parties. The grievance of the petitioner with regard to installation of the mobile tower is not only on account of the same not having been done in terms of inverted commas guidelines for issue of clearance and permit for installation of mobile towers in Assam and disposal of public grievance in this regard, inverted commas close, but also due to the fact that the mobile tower is the source of harmful and hazardous radiation instead of it's a electromagnetic radiation.
Electromagnetic.
And electromagnetic radiation. That's all. That's the case. On perusing the affidavit of the respondent number 10, it is seen that the respondent number 10 has taken a stand that the installation of the mobile tower had been done after prior permission of the Deputy Commissioner Kamrupan had been taken for construction of the same. The above being said, comma, the division bench of this court in PIL number 88/2013, which was disposed of on 16/6/2016, had the occasion to deal with a matter relating to installation of mobile towers. PIL number 88/2013 was disposed of by directing the you just take it from there, by directing the I just order dated 27/5/22, directing the from here. Okay, till there. Next time. Clause 17 of the guidelines provides that if there is any grievance relating to the establishment or operation of a mobile tower, the same shall be placed before the DTC. Thereafter, if aggrieved, the complainant can always file an appeal before the State Telecom Committee (STC) within 45 days thereafter. As there is an alternative remedy available before this court, this court is of the view that the present writ petition can be disposed of. No, this court is of the view that the petitioner that as the petitioner has an alternative remedy available, the present writ petition should not be kept pending any longer before this court. Accordingly, the writ petition is dismissed with liberty being given to the petitioner.
Dispose of your
is closed with liberty being given to the petitioner to approach the DTC in terms of clause 17 of the guidelines with regard to his grievance. With regard to her grievance. This is C. With regard to her grievance. In the event, the petitioner submits her application, the same should be disposed of by the DTC. Within a reasonable period. No. There too is so many parties. Reasonable period. You come in the year 22. What hurry? Now suddenly you wake up.
No, your lordship, initially order was there, your lordship, by the authority. Then suddenly, your lordship, he again started crossing, that's why.
The petitions accordingly disposed of.
On the first day, your lordship, I make this prayer.
Huh?
On the very first day, my prayer was this, your lordship. Somehow, your lordship.
You got your prayer.
Your lordship.
Sometimes it comes, but that is, you see, that is what the thing is. Sometimes you pray for something, you get some another thing. that is also there.
Deeply obliged.
Yes.
Mr. Lordship's matter regarding demarcation of land value. The petitioner passes a plot of land value 1 bigha 3 gata 15 lesa in the year 2011 matter. 2009 matter. Subsequently, my lord, the landowner of the adjacent land, my lord, has broken the pillars, my lord. Accordingly, the petitioner approached the authority for demarcation at page 32 in the year 2011. Since 2011, my lord, the petitioner submitted representation before the authority for demarcation, my lord. But the authority has not taken any action, my lord.
Yes.
That part, my lord, in the recently, my lord, the petitioner filed an application under RTPS Act for demarcation, my lord. That also pending before the authority, my lord, but has not taken any action. After filing this writ petition, he has again filed the petition under RTPS Act.
What is RTPS Act?
RTPS Act, my lord. Right to
Public Service Act.
Public Service Act. my lord. And as per RTPS Act, my lord, the authority ought to have taken action within 30 days, my lord.
Okay, under which provision?
Provision, my lord, section 8(1).
8(1).
8(1). Any person who does not get notified service within the stipulated time specified under section 4 or is specified agreed by a decision of the designated public servant may within 30 days from the expiry of the stipulated period or from the date of receipt of such decision as the case may prefer an appeal. And my lord, not yet. 30
Prefer
days
an
or-
appeal to whom?
Appeal to my lord ADC, additional.
Then you
deputy.
file it before ADC.
But my lord, not yet completed 1 month, my lord.
1 month completed. This is
My lord,
on
yes,
2/2.
my lord.
1 month completed. 1 month completed on 2nd March.
2nd March, my lord. And the appellate authority ought to have taken action within next 30 days.
Correct.
After
Then
30.
where is your appeal to the?
My lord,
Where is your appeal?
as per my instruction, my lord, today is going to be filed the appeal, my lord.
Then this becomes infructuous.
Not yet in success, my lord.
Why not? Why not? You cannot have parallel proceedings, Mr. Counsel.
My lord,
You cannot have parallel proceedings. If you had not shown me this,
yes, my lord.
maybe I would have allowed.
Yes.
But since you have already availed of this, I cannot allow you to take now. And then you are saying just now you have said that you are going to file an appeal today.
Yes.
When you see, then you wait for another 30 days, you file.
Yes, my lord.
And if nothing happens,
No, my lord.
then you come. Is there any further appeal after that?
No.
Review also
Yes, my
takes
lord.
further.
There's a review.
Review also there, my lord.
Deputy Commissioner is added in it.
Deputy Commissioner. my lord.
You avail that. You just wait for another 2 months, 3 months. You can then you come here.
My lord, then let the matter be pending.
No. I'm going to dispose it out. No.
Then my lord, directed the authority to dispose of the petition, my lord, filed on 2nd of February.
No. You're filing an appeal, you said just now.
Not yet filed, my lord.
Not yet filed, you file.
Not yet filed, my lord.
You cannot be too smart.
My lord.
You cannot be too smart for yourself only. You have got to, you see. If you had been quiet about this, maybe, but then since you have brought up this thing which I didn't know about.
My lord, then let the matter be keep pending. my
No,
lord.
no.
And not directed the authority to dispose of the petition, my lord. As per the RTPS Act. Yes, my lord. Since 2011, my lord,
Why did you file this?
because my lord, in the recently this honorable court directed to file the RTPS in many other cases, my lord. That is why the petitioner filed the petition, my lord. In some other cases, directed to file appeal under this provision, my lord.
You file an appeal.
No, my lord.
We'll direct that you file an appeal. No, we'll say that if you file an appeal, that should be disposed of.
Yes, my lord.
Because this we cannot, well, 30 days have gone. We
Yes.
cannot say that
Yes,
it will not be proper.
We will file
What do you
the-
say?
Lordship, this honorable court has passed some, disposed some petition
Yes.
regarding this remark.
Okay, this should.
Lordship, may I say, huh?
No, it's correct. He'll take the alternative remedy. But the thing is that you see, even the circle officer should have done his job. Now, since he has not done his job, if he files an appeal within the as per the provision, once the appeal is filed, then the appellate authority should do their job. That's all. Only to that aspect. Provided, of course, he files his application within the prescribed, as per the prescribed format. And all the relevant documents are included.
Actually, there is no any prescribed
Huh?
with the act, my
Prescribed.
lord.
Ah.
There is no any prescribed format.
There's no any prescribed format.
No, my lord. There is no any prescribed.
Huh?
This is the act, my lord. There is no any prescribed format. Office memorandum is there also.
There's a prescribed format.
Yes. No, no. Yes. This is in respect of my lord designation.
No.
21st December.
There's an office memorandum
Yes, my lord.
of 21 December 2020.
Yes, my lord.
And their applicant has to apply in standard application format.
But there is no any format, my lord. This is the notification, my lord. Only here mention, my lord, user charges 30 rupees.
Okay, anyway, you do that, we'll see.
Yes,
Right. Heard, Mr. M. Hussain, learned counsel for the writ petitioner. Writ petitioners. Also heard Mr. N. Goswami for respondent number
2, 3, and 4.
2, 3, and 4. And Ms. G. Hazarika for respondent number 1. The petitioner's grievance pertains to the fact that their prayer for demarcation of land and correction of map has not been considered by the authorities till date. Full stop. Next para. The petitioner's counsel submits that the petitioners had purchased a plot of land measuring 1B-3K-15 lechas covered by Dag number 251, Khiraj Miadi number 92, Khatian number 15 of village Bilasipara Sadar under Bilasipara Revenue Circle in Dhubri district, Assam, from the Patedars by registered sale deed dated 23/3/2019. Thereafter, the land has been mutated in the name of the petitioners and they have been in possession of the same till date. Tell me one thing, who are these adjacent land holders who have
Earlier landholder.
No. You have said out here at page 7. Later on, the owners of the adjacent land had broken the pillars and encroached land. Why are they not parties here in this writ petition?
Because my lord, we have mentioned in our petition, my lord.
Whatever I said.
My lord.
The petitioners, further case is that they had installed pillars along the boundaries of their land. Full stop. However, the owners of the land adjacent to the petitioner's lands encroached upon their lands encroached upon their lands. Full stop. Finding no alternative, no, full stop. The petitioners thereafter submitted petitions before the settlement officer, Dubri and Kokrachar districts to demarcate the land of the petitioners and to make correction to the map, if required. Full stop. The petitioners had submitted their representation in the year 2000 on 16/3/2009. Brackets annexure 2. By 2. Next paragraph. The petitioners council submits that as no action was being taken by the respondents for demarcation of their land and correction of the map, the petitioners submitted an application dated 2/2/23 under Section 4 of the Assam Right to Public Services Act 2012 as amended up to date, hereinafter referred to as the 2012 Act, for correction of the area of the land / dug in the map and to demarcate the land. The application, which was addressed to the circle officer assistant settlement officer, Bilasi Para Revenue Circle, Assam, has not been acted upon by the authorities till date, and as such, the petitioners are going to file an appeal in terms of Section 8 of the 2012 Act. Next paragraph. The learned counsels for the respondents submit that the writ petition should be dismissed as an alternative remedy is available, which the petitioner has availed of by filing an application under Section 4 of the 2012 Act. In this regard, they have relied upon the order dated 18/5/22 passed in WPC 2743/22. Next paragraph. On perusing the order dated 18/5/22 passed in WPC 2743/22, this court finds that in a similar set of facts, this court had declined to continue with the writ petition as an alternative efficacious remedy was available under the 2012 Act. The above being said, the petitioner in this writ petition has taken a stand has averred in para 6 that the owners of the adjacent land had broken the pillars erected by the petitioners and had encroached the northwest and southwest corner of the petitioner's lands. However, the names of the adjacent landowners have not been reflected in this writ petition, and neither have they been made parties.
My lord, their name is there, my lord,
Where?
Annexure 9, my lord.
Annexure 9.
Yes, my lord. Page 44, my lord.
Just say, and don't say reflective, just say, and they have not been made parties in the writ petition. Huh? No, have not been made parties in the writ petition. Full stop. In any event, comma, as the petitioner have already availed of the alternative efficacious remedy by filing an application under Section 4 of the 2012 Act with regard to their grievance, and as they have a right to file an appeal under Section 8 of the 2012 Act, if the Section 12, if the Section 12 application is not considered by the respondents, comma, this court is also of the view that the present writ petition is not maintainable. No, this is of the view that the present should not be kept any longer, should not be kept pending any longer in view of the above reason. Accordingly, the writ petition stands closed, with liberty being given to the petitioner to avail of the alternative remedy available in terms of the 2012 Act, whether it be for waiting for a decision in respect of the petition's application under Section 4 or filing an appeal under Section 8. The writ petition is accordingly disposed of.
Right, your lordship. Petitioner before your lordship is a very poor but meritorious student, your lordship. And he has approached because of non-grant of the educational loan by the respondent bank authority, your lordship. If
Come
the
to para 4 of the affidavit of position.
lordship.
Please read.
Where the admission is purely based on marks scored in the last qualifying examinations, cut-off percentage of marks of 50% for SC/ST and 60% for
No,
others.
no. Para 4.
Para 4. Okay. That in reply to paragraph number 6 and 7 of the writ petition, the answering respondent bank does not deny the correctness of the fact that the petitioner approached the bank at its Binnagandi branch for a loan under the PNB Saraswati Education Loan Scheme. It is also not denied that the petitioner submitted various documents along with the online application to obtain the said loan. However, after the IPA Model Education Loan Scheme was formulated, the respondent bank has issued a consolidated circular dated 9/6/2022 for all education loan schemes for pursuing higher education. The PNB Saraswati scheme is one of the schemes formulated for granting educational loans for pursuing higher education in India. Under the said scheme, the eligibility criteria is as under. Number 8, where the student has obtained admission in eligible course through merit-based selection process, he or she could be considered meritorious. Generally, admission to professional and technical courses is through common entrance test, and those who get admission through this process be considered meritorious. Where the admission is purely based on marks scored in the last qualifying examinations, cut-off percentage of marks of 50% for SC/ST and 60% for other categories be considered. However, the ATM, RAM, and CHCSE and above may consider the case on merit where admission is purely based on marks scored in last qualifying exam, and the student applicant has scored less than the stipulated cut-off mark of 50% for SC/ST and 60% for other category. The petitioner has applied for the educational loan for pursuing diploma in pharmacy from Shifa Pharmacist Institute without any common trust, and hence he is not covered by the eligibility criteria above. The admission process of the said institute is not purely based on the marks scored in the last qualifying examination. Yet, even considering the case of the petitioner under the eligibility criteria B, it is admitted that the petitioner has appeared for the higher senior examination twice, that is in the year 2018 as well as 19. In the academic year 2018, the petitioner scored 194 out of 600, that is 32.33%,
And the year 2019, he scored 203 out of 400, that is 50.75%. As he is an OBC and not an SC/ST candidate, he is not entitled to the benefit under the eligibility criteria B, and hence he cannot be sanctioned the loan under the PNB Saraswati scheme. The rest of the abatements in the said paras under reply are denied. Now your lordship will come.
Let us see your your application
Lordship, application
for the loan.
at page 20, your lordship. It has to be made online, your lordship. They have to give details, your lordship.
So you have asked for this loan under the PNB Saraswati scheme,
Lordship.
correct?
And I have asked for a loan of rupees 2,84,000.
No, I'm not talking about the amount. Amount is of not relevant here. So now the PNB Saraswati scheme, according to them, requires that it has to be a merit-based selection process. And in your case, there was no common entrance test. And they are not covered by eligibility criteria. What do you have to say to that?
Lordship will kindly come to page number 17
Of the writ petition.
of the writ petition. The result of the merit-based selection process test. It is not that it was given on the marks of the last exam. It was both, your lordship, the marks of the last exam as well as the interview that they have conducted, your lordship. The petitioner is the serial number 3. It is not that there has to be an entrance test it must be a merit-based selection process. That is what the RBI circular says, and they cannot supersede this RBI guideline, your lordship. Maybe they have not contacted, but it is not purely on the basis of the marks of the last qualifying examination. It is two-way, your lordship, merit-based as well as the marks scored in the last examination. And he has got already admission, your lordship, but he could not pay the fees, your lordship, except the first installment. But you will see the RBI guideline, RBI circular, that is the main circular, and from that circular they have deducted DRPNB. This is binding, your lordship, at page 23. This has been formulated by the RBI.
It's not RBI.
RBI in association with Indian Bank Association, your lordship, in collaboration with Indian Bank Association. And this is a model guideline that has to be followed, your lordship. Objective of the scheme, lordship, will see at page number 23. The educational loan scheme outlined below aims at providing financial support from the banking system to deserving meritorious students for pursuing higher education in India and abroad. The main emphasis is that every meritorious student, though poor, is provided with an opportunity to pursue education with the financial support from the banking system with affordable terms and conditions. No deserving student is denied an opportunity to pursue higher education for want of financial support. That is what is the main objective of this scheme, your lordship. Now, who are the students eligible? That is also being given, your lordship. And I am covered under this also. Courses eligible at 4.2, page number 24. There are a number of courses. I'll come in.
Where? Page 24.
24. What are the courses eligible? So I'll come at 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Other courses, lordship will find at point number 10. Other courses leading to diploma degree conducted by college universities approved by UGC, government, AICT, AIBMS, ICMR, etc. Now I am pursuing 2 years diploma course, and the institute is recognized by the Pharmaceutical Council of India, which is the competent authority to give recognition, your lordship. Now at page number 24, just at the beginning, your lordship, 2 conditions are there. Should be an Indian national. This is the first condition. And secured admission to professional technical courses in India or abroad through entrance test or merit-based selection process. 2 things are given, your lordship. It must be an entrance test or it must be a merit-based selection process, your lordship. And my case is that I have got admission through a merit-based selection process, your lordship. And the whole course.
You see, you just come to page 23. Just come to applicability of the scheme.
Lordship. The scheme detail below could be adopted by all commercial
Could
banks.
be, could be adopted.
Could be,
Now you just show me whether this scheme has been adopted by this bank, Punjab National Bank.
Yes, they have adopted, your lordship.
Where?
This is the PNB because we have followed all the guidelines of this scheme, your lordship. The PNB Sharafpuri scheme. Lordship, I'll read further. The scheme provides broad guidelines to the banks for operationalizing the educational loan scheme, and the implementing bank will have the discretion to make changes suiting to the convenience of the student's parent to make it more customer friendly. They can make some addition only for the betterment of the students or for.
They see, not only that, that is the second part.
Lordship.
The first part is that it has to be adopted by the concerned bank. Show me this adoption of this scheme by the PNB.
They have also admitted, your lordship.
They have admitted.
They have followed this scheme, your lordship.
He is shaking his head the other way. If this is yes, so then you are correct. But then if this is no, then you are on a different page. You tell me.
In fact, this is the scheme being adopted by all the banks, your lordship. There is no.
No, I'm not on that. There's nothing. I just want some proof because he's shaking his head the other way. How you interpret and how I interpret is different. But then that's what to do. Now we'll have to ask how he interprets his own shaking of his own head. Yes, anything else? No, you don't have that. Okay. Okay, then next point.
Next point, your lordship. Now, they will cover only the course fee, your lordship. So I have given the course fee also. The course fee is almost 2,90,000 at page number 18, your lordship. 2 years to course fee, your lordship. Page 18, 2,90,000. He applied for a loan of 2,84,000, your lordship. And your lordship, when the amount is less than 4 lakhs, your lordship, even no collateral security, nothing is required, your lordship. Only the thing that is to be ensured is that he is into a professional course, and there is a probability of being employment after this. Now he is doing the diploma in pharmacy, which is a very fruitful course for getting employment, your lordship. And third, your lordship. If this loan is not sanctioned, your lordship, he will be thrown out because he belongs to a tea labor community, far-flung area, tea garden area, your lordship, and obviously, your lordship. In this regard, I would like to rely on one judgment of Kerala, your lordship, in a similar line, your lordship. So it's not our high court.
No, first you show me this scheme that he's talking about. Why is the judgment? Then you'll have to go to Kerala and maybe argue a case there. First, you have got to base your arguments on the basis of the scheme that is being applied.
May I read the introduction part of this, of the scheme, your lordship, page number,
Huh?
page number 23, introduction part. There it is.
Yeah.
Education is central to human resources development and empowerment in any country. National and state level policies are framed to ensure that this basic need of the population is met through appropriate public and private sector initiatives. While the government endeavor to provide primary education to all on a universal basis, higher education is progressively moving into the domain of private sector. With a gradual reduction in government subsidies, higher education is getting more and more costly, and hence the need for institutional funding in this area. The scope of education has widened both in India and abroad, covering new courses in diversified areas. Development of human capital is a national priority, and it should be the endeavor of all that not deserving student is denied opportunity to pursue higher education for want of financial support. Loans of education should have been as an investment for economic development and prosperity. Knowledge and information would be the driving force for economic growth in the coming years. Based on the recommendations made by a study group, Indian Bank Association had prepared a model educational loan scheme in the year 2001, which was advised to banks for implementation by Reserve Bank of India by circular number dated so and so, along with certain modifications suggested by the Government of India. In line with the announcement made by the Honorable Finance Minister in his budget speech, IB had communicated certain changes in the security norms applicable to education law, which limit from rupees 4 lakhs and up to rupees 745 lakhs. So this scheme was directed by RBI to be followed by all the banks, your lordship. We have been receiving inquiries from members seeking clarification on the various provisions of the scheme based on feedback received from the bunches, with a view to ensure that the scheme is implemented in letter and spirit. It was decided to review the scheme and make modifications in the scheme to facilitate smooth operation at bank branches. Towards this, a working group for general managers drawn from Select Bank was constituted at IPA. This revised model scheme has been prepared based on the suggestions made by the group. So the Indian Bank Association, your lordship, it is an amalgamation of all the banks. And this was done in consultation with the RBI, and this is required to be followed. And they have this Saraswati scheme that they have adopted, your lordship. This is in tune with this, the model educational loan scheme formulated by the Government of India in consultation with the Indian Bank Association. My lord, only a meager amount of 2,84,000 he is seeking, your lordship. Yet work admission through a merit-based selection process from a Tilakar community, your lordship.
You see, it's not a question of the money, whether it's 2 lakhs or 50,000 or 10 lakhs or 20 lakhs. It is whether you come within the scheme or not, that's all.
Definitely, your lordship.
If you say the money is 2 lakhs or 4 lakhs, small amount, then everyone will want it, and then it doesn't become a small amount when you talk about lakhs and lakhs of students. I just want to know whether you're covered by the scheme or not, that's all.
Gotcha.
That's all. That's all.
Even otherwise, under their scheme also, your lordship, I have got admission through a merit-based selection process. So the marks that I am required to get 60%, that will not come. That is their case is that
According to you, you have gotten through a merit-based
selection process, not on the basis of the last qualifying marks only. It is a merit-based selection.
So merit-based selection.
At page number 17, your lordship. The second.
How do you say it's merit-based?
Page number 17. What you could see. The candidate number 1, he has got in HSLC 67% marks, in HS higher secondary 60%, and then in personal interview they have conducted, your lordship. That they have given a marks of 43, your lordship. And third is the petitioner, though he got better marks in HSLC, but he got less marks in HSLC, and he also got 43 interview.
So all these are the selected persons.
Lordship.
All these persons.
Selected persons.
Selected persons.
So on the basis of the last qualifying marks as well as the.
Who are the persons who are not selected?
That I have not got the list, those who are not selected. But it is also a personal interview. That is, apart from the last qualifying marks, they have ensured that they have tried to find out the merits of the students also, your lordship. Merit-based selection process. Not entrance test, but it is a merit-based selection process, your lordship. And it has to be interpreted generously, your lordship, keeping in view the broad objective of the scheme.
Generously. Oh.
Even the PNB scheme that they have said, your lord, in their affidavit, they have said that the main emphasis is that a meritorious student, though poor, is provided with the opportunity to pursue education with the financial support from the banking system. At page number 36 of the affidavit in opposition, their scheme, your lordship.
That's all.
Lordship will kindly say page 36 of the affidavit in opposition.
Yes.
So objective they have in tune with the IBR model
Correct.
scheme, and then while considering the eligibility, your lordship, there are two conditions. One, where the student has obtained admission in eligible course through merit-based selection process, he should be considered meritorious. Generally,
Where are you reading?
at page 36, point number C,
Hmm.
while considering eligibility criteria, page 36 of the affidavit in opposition.
So, please read.
Where the student has admission in eligible course through merit-based selection process, he or she should be considered meritorious. Generally, admission to professional technical courses through common entrance test, and those who get admission through this process be considered meritorious. And secondly, where the admission
So it says that through common entrance tests and those who get admission through this process be considered meritorious.
First, they have said that where the student has obtained admission in eligible course through merit-based selection process, he or she should be considered meritorious. And then generally, your lordship, merit-based selection process is done through common and through an entrance test. That is a clarification to the first line, your lordship. Now, it is not that all the times it should be there should be a selection test, your lordship, or an entrance test, your lordship. There may be other ways also to find out the merit-based selection process, your lordship. That is my submission. And the second point will come only if the first point is not qualified. That is, if the student does
So
not.
anyway, you are not pressing on the second point. You're
I'm
pressing
not-
only
I'm
first point.
First point, your lordship. And I pray for a legal interpretation and for grant of the adoption loan, because his future is dependent on this, your lordship.
Yes.
But as far as fiscal matters is concerned, the liberal interpretation should be very carefully given. Lord, as far as the point A is concerned, the issue is that the merit-based selection process and common interest test. Now, my lords, the heading of as far as common interest test, it implies that anybody who comes into a common interest test such as CUET, CAT, MAT, those type of tests, those candidates we automatically we are considering for selection. Because my lord, those are on a pan-India or pan-zonal level.
No,
These
no.
are not
Okay.
localized.
So which course did he apply for?
He applied for this pharmacy.
Diploma in pharmacy, 2 years diploma in pharmacy course. This is very rare course, not started.
Diploma in pharmacy course.
Pharmacy, 2 years diploma.
So that if your lordship comes to the point A, in point
Which
A,
page are you reading?
lordship can come to page 36.
Yes.
He has read, but again, I will take your lordship to that. Now, if your lordship to comes to the point 2C, while considering the eligibility, where the student has obtained admission in eligible courses through merit-based selection process, she could be considered meritorious. Generally, admission to professional and technical courses is through common interest test, and those who get admission through this process be considered meritorious. So, if somebody comes in through a common interest test, there is no further doubt about his capability or his eligibility. He automatically is entitled to the loan if he is from that category. As far as the point that my learned friend is harping on, that he has come through the merit-based selection process. These candidates, all of them will not be automatically entitled, because what is a merit-based selection process? Merit-based selection process implies that there are a large pool of candidates. It's on a pan-India or pan-zonal level, and therefore thereafter he has got a good rank. Now,
But where are you saying all this from?
These are as far as the common interest test is concerned. My instruction is that this is automatic. Had he come in through let us say a CAT exam, CUET exam, MAT exam, these are automatic. They are getting the loans. For example, somebody comes in through the joint entrance examination. He automatically.
But what about this word generally that's coming here?
Yes, generally, so generally, admission to professional and technical courses. Now, his course is also a technical course. One has to hold that is a technical course only. Is through common entrance test, and those who get admission through this process be considered meritorious. So those who are coming in through the common entrance examination, automatically they are considered as meritorious.
Correct.
No further.
But what about sir? But sometimes
Yes,
they need
could
not
be
come under
considered.
that.
Yes, could be considered. But in this case, we find a candidate who has got the as far as his 10th marks is concerned, it's about 50%, and as far as the 12th marks are concerned, he's got first division. This is a localized selection process, based on this particular institute. There is no selection list in which the number of candidates is indicated. There is any cutoff mark. There's nothing like that. So if we start giving all the candidates like this, the loans, then it will lead to a big problem. So as far as the first part of point A is concerned, the bank has the discretion to consider or not to consider somebody as a meritorious. But as far as the second part of point A is concerned, somebody comes in through a common interest exam, he has to be given. There is no scope for discretion at all. That we admit.
So what is your, so why the decision you have taken that he's not meritorious?
Lordships.
Where is that decision?
Well, there is no impugned letter or nothing that he has raised. The application was just.
So you have not given any reasons
There's
for
no
why he's
reason
not.
as such, no reason.
You have not filed any affidavit as well?
Yes, we have filed affidavit.
Where
That
is
is the- I was reading from the affidavit.
Okay, you are reading from the
Yes.
affidavit.
And that affidavit.
So
we have provided
why have you said that he's not meritorious?
this part. The very same page 30 onwards, where paras A and B, and we have said, the last paragraph, this part, the petitioner has applied for the education loan for pursuing diploma in pharmacy from so and so without any common entrance test, and hence he is not covered by the eligibility criteria A above. The admission process of the institute, this part, since he is not harping on B, so I am not pressing that part. But we do say that it is admitted that the petitioner has appeared for the higher secondary examination twice, in the year 2018 and 2019. In the academic year 2018, petitioner scored 194 out of 600, that is 32.33%, third division. And in the year 2019, he scored 203 out of 400, that is 50.75%. He is as he is an OBC and not an SC/ST candidate, he is not entitled to the benefit under eligibility criteria B, and he cannot be sanctioned under the loan under the PNB Saraswati scheme. This is the matter. As far as A is concerned, there are two parts clearly. If he comes into a common interest test, we are bound to give him that benefit. He is automatically entitled to it. But as far as merit-based selection process, the bank has a discretion because it's a question of public money. There are so many cases where even doctors have gone to Australia, not a penny has been repaid. And then there have been cases filed in this court. And he has not challenged the interpretation of the scheme, no rejoinder or rebuttal has been filed. This interpretation of courts. The IBA scheme is a broad guideline. It provides a framework. It is not absolutely binding. It's not an RBI circular. The RBI circulars have statutory flavor. They are binding on us. We would have to follow every word. But this is an IBA. General managers of certain banks were got together. They developed a framework. We are acting on the framework, but the scheme is ours.
Yes, anything else? Yes.
Because the first part he is trying to say is that it is not a merit-based selection process, and according to him, the merit-based selection process must be an entrance test. It is not the case of the Lordship. Generally, in courts,
No, okay, assuming that it doesn't have to be a selection process, that doesn't have to be exam. But can't there be some discretionary power given to them to choose who is meritorious or not? If there is no examination, or is it who will decide whether he is meritorious or not, a candidate? Who will decide that? Some discretion has to be given to them.
the fact that he has been selected, Your Lordship,
Doesn't mean that everyone who is selected can be, a person can be selected for English honors or BA honors or geography honors, everyone.
that is what the scheme says, Your Lordship. It generally the selection of the students indicate his
With regard to what courses?
courses. They have it is there, Your Lordship, in the scheme itself.
Yes. But for what courses? We'll take it up at 2, huh?
So इशारा करना पड़ता है। हाँ, ये बुक है, लेकिन हम जो है ना, वो सही है।
Okay, good for me. The appellant is acquitted of the charge under section 302. State respondent is directed to immediately release the appellant from jail.
Do you want to continue?
Mr. Senior Counsel, court number 1.
Code number 1.
1, yes. Lord.
Yes, so I think what else is there to be said?
There are only cases that I have not been selected through a selection, merit-based selection process. And there are cases that it must be through entrance test.
Huh?
There are cases that if it is an entrance test. This is not the case, Your Lordship. The word used is merit-based selection process. There are two, either it must be a merit-based selection process or it must be on the basis of the last qualifying marks. Two conditions are there. If merit-based selection process, a person gets admission, the student has to be considered meritorious. Now, they have said that since my admission, they have not considered it to be a merit-based selection process. The other things, how many students applied, this is not the case. This is the case, Your Lordship, where I have filed documents to show that he has been admitted to a selection process, Your Lordship. It is not that on the basis of last qualifying examination, he has been selected, Your Lordship. Your Lordship, these are the schemes with social and moral objectives, Your Lordship, not for only, it is not that for some expansion of his business or something like that, Your Lordship. He has already got admission, he has already completed three semesters also. He is at the part of coming out of the exam. The only thing that is to be seen whether there is employability of the student concerned. Lordship. Admittedly, it is a professional course, Your Lordship. 2 years diploma in pharmacy. Had the criteria said that admission through entrance-based selection process, that would have been a different. But the word is merit-based selection process, and generally it is said that entrance test may be conducted.
Okay, is your, you see, you are doing diploma in pharmacy course.
Pharmacy course.
Is this an eligible course?
Lordship, it is an eligible course.
Where?
In their affidavit, in their scheme, Your Lordship, at page number 38. Courses eligible is there. Lordship has got it.
Yes.
At point number D, regular degree or diploma courses like aeronautical, pilot, training, shipping, nursing, or any other discipline approved by the Director General of Civil Aviation, Shipping, State Nursing Council, or any other regulatory body as the case may be. Now, this is a case, Your Lordship, he is doing diploma in pharmacy, and the institute is recognized by the Pharmacy Council.
But is it how does it come under D?
It comes, Your Lordship.
Where?
Or any other regular degree or diploma courses like, these are some of the examples given: aeronautical, pilot training, shipping, nursing, or any other discipline approved by the Director General of Civil Aviation, Shipping, State Nursing Council, or any other regulatory body, Your Lordship. Now, Pharmacy Council diploma in pharmacy, it is recognized by the Pharmacy Council of India, which is the.
Is it recognized by the State Nursing Council?
It is also recognized by the State Nursing Council.
Huh?
Because
Nursing Council, nursing and Pharmacy, the pharmacy is different.
It is recognized by the Pharmacy
Then,
Council of
huh?
India.
Huh?
Pharmacy Council of India.
Maybe, but then
No, these are state announcing council or any other regulatory body as the case may be. It's in respect of this degree, affiliation from nursing council is not required. It is required from Pharmacy Council of India. And I have annexed your lordship. This course has been, this institute has been recognized by the Pharmacy Council of India, lordship. And to that, they have also no objection. There are only cases that the admission is not through merit-based selection.
no, you just write.
Its future will be jeopardized, dear lordship.
The one of the questions that has arisen is whether the educational loan would cover diploma in pharmacy course. Keeping in view clause 2 bracket D, small d, bracket Roman 2, small, bracket D. Bracket page 58, page 38. Very close. This is there. Yes, there is one question whether this diploma in pharmacy course can be considered to be a eligible course for grant of educational loan. Keeping in view page 38. D at the bottom.
So, since it appears that the institute is approved by the Pharmacy Council, it appears that they have annexed a certificate which shows that the institute is approved by the Pharmacy Council. So perhaps, my lord, under D he may come. That's not the ground that we have rejected. I must be fair with your lordship. That is not the ground of rejection. The ground of rejection is that, my lord, the merit-based selection process, the first part is not squarely applicable across the board. It has to be restricted to a definite category. And the second part, whoever comes in through the common test, everybody gets it.
Comes into the common?
Through the common entrance test. If somebody comes in through a common entrance test, let us take, for instance, if there is a BTech course or a BSc course, even if he comes in through the CUET, let's say the Common University Entrance Test, we have to give him the loan because that is a common entrance test. That is it's a pan-India examination. If somebody qualifies, automatically he is entitled. But here, in the first part, there has to be an element of discretion, as in the tender matters, lordships are free play in the joints. There has to be some amount of discretion, objective as well as subjective, because otherwise, every person, every student who comes through this type of a process, assuming that we can call it a merit-based, because as your lordship rightly pointed out, there is no selection sheet as such, showing that, let us say, 100 students had applied, and out of that 10 have got, or 6 have got, or 5 have got. Here is a sheet which indicates that these are the candidates and this is the position. We do not know what kind of selection process has come. And as far as even then, considering the meritorious part, we have shown that he got third division in the matriculation examination and he appeared 2 times in the HSS-LC examination. So, as to that aspect, otherwise each and every one, it's a fiscal matter. Ultimately, it's a question of money. And another aspect, that he has taken admission in the course. Now we are at the end of the first year. He was supposed to pay 1,42,000 as far as the calculation goes. 1 lakh towards the court fees for the course fees, and 42,000 the hostel books, etc. That was the payment he has to pay. That is why the loan is for 2,84,000. Now we are at the end of the first year. Whether he is still studying, whether he has paid, we do not know. If he has studied.
This course is for which period?
2 years.
For which period, for which date?
From 2021 to 2023. By this time, you will be completing your lordship.
2021 to 20, which month?
Lordship
Which month?
starts from May 2021.
May 2021 to May 2023.
We are almost complete.
Are you studying or what are you doing?
Even he has got a shockers that if you don't pay the fees, you will not be allowed to sit in the fourth semester exam. He has paid only the first installment of rupees 50,000 at the time of admission. And thereafter, he has said that we have approached the authority for grant of loan. So that he was continuing your lordship. Subsequently, he has not paid. I will place on record your lordship that he has been shockers by the authority that he will not be allowed to appear in the fourth semester, last semester exam, your lordship. I may file an additional affidavit in this regard if the lordship requires. No, that is, I have
Not really
instructions.
pressing. I was just on the point that.
It is not for money I have come, your lordship, to continue the course, your lordship. I have admitted that I have given the first installment. My father has taken loan from different people. He's a tea garden laborer. And 50,000 at the time of admission he has given. And thereafter he has approached Bank Authority for the educational loan, your lordship. Initially they considered, but subsequently they were hoping that he give a collateral security, to which he could not give. Thereafter they did not, because his father has no any property to give a collateral. So that is what he has said. Thereafter, we have approached this honorable court because they were neither accepting nor granting. Now, by way of this affidavit, they are stating that he has not got admission through merit-based selection process. But the initial I have in my writ petition, I have stated that only because they were asking for a collateral security to be given for the loan, to which the petitioner could not furnish. That was the initial reason. But
You see, one thing is when did you apply for the loan?
lordship, date of application is that I applied on 6th of April 2022.
6th April 2022. So your course started in May 2021.
Lordship.
And 1 year later only you have applied for the loan.
Since his father could not manage a lordship, thereafter the authority said
Oh,
that
since his father could not manage.
a lordship.
Let us see your application.
Lordship. Application at page number 20, your lordship. There is actually no such application in the form. It is a standard format application, your lordship. It is through online, they have to submit, your lordship. I have stated that my father has given the first installment, but subsequently he could not pay, your lordship.
And you are staying in a hostel.
Staying in a hostel.
You're staying in a hostel. Hostel fees are being paid.
That is also not able to pay, your lordship.
They're not being paid. So you're being given free food. You're eating in a gurudwara or something, langar or something. Yeah?
But first installment he had given, thereafter he could not give, your lordship. It is not that for money he has approached this court, your lordship. Complete the court, your lordship, he has come before this honorable court.
You have come for money. That's all.
I'll file an additional affidavit if required, because they are saying that how many students participated in the all these
Right.
things if required, your lordship, I'll file.
Mr. M.H. Laskar, learned counsel for the petitioner submits that the petitioner has applied for the education loan on 6/4/2022. While he has undertaken the course for diploma in pharmacy for the period May 2021 to May 2023. On his prayer, 2 weeks time is granted to file additional affidavit. This is the matter thereafter.
Obliged. I'm deeply obliged.
Correspondent number 1, my lord. The petition has been filed by the Board Territorial Council seeking review of the order dated 8/1/2014, my lord.
Huh?
This review petition has been filed seeking review of the order dated 8/1/2014. The petition was filed in the year 2014.
8/1/2014.
Yes, my lord. And they have kept it effective for 3 years. It was registered only in the year 2017. Kindly come to the order under review at page 20, my lord.
Item number 26.
26, my lord.
What happened to 25? Adjourned. Adjourned. Okay. Yes, so this review petition, you see, you have not taken steps.
No, I'm respondent, I'm not the petitioner.
Oh, yeah.
I am the respondent number one, the review petitioner. my
No,
lord.
I think he has not taken steps at all.
Not at all, on earlier two occasions, it reflects on the Honorable Rojima Court's order 14.3. My lord, will kindly see how things has folded, unfolded.
Unfolded.
Unfolded, my lord. Order was passed on 8/1/2020.
Okay, right. No one appears for the petition on call. This is an application. This is a review petition.
No ground, I think.
Huh?
There is even no ground.
This is
There
a
no
review
error occurred
petition
on the
for
place.
review of the
Order dated 8/1/2014,
8/1/2014,
passed in WPC number
passed in WPC number
107/2014,
107/2014.
annexure 4, page 20.
Good stuff. Hmm. Order dated 8/1/2014, passed in 107/2014. Good stuff. The review petition was filed on
Test 10, my lord, 27/11/14.
on 1/12/2014. The records show that the orders passed by this court show the orders the records show that despite the directions of the Lavazima court for Lavazima court directing the petitioner to take steps for service of notice in respect of the respondent number 2. By orders dated 17/11/22 and 10/1/23. No steps have been taken by the petition. Mr.
And G. Jalan.
G.
Jalan,
Jalan appears for
respondent number 1.
respondent number 1. It is also noticed that no one had appeared before the Lavazima court on 14/3/2023. The continued inaction of the petitioner, review petitioner, in not taking steps for service of notice upon the respondent number 2 and non-appearance before the Lavazima court gives rise to an inference that the review petitioner is not interested in pursuing the review petition. So accordingly, the review petition is dismissed for non-prosecution.
This is according to demarcation of land, my lord. Till now, my lord, respondent number 4, 5, 6 not appeared. We already justly taken upon respondent number 4, 5, 6 on 6/2/2023, my lord. Also file affidavit.
As per the last order, you were supposed to take fresh steps by a registered post as well as by trustee. Have you taken the normal service steps for normal service?
For the justice service present on 6/2/2023.
6/2/23. 3-2. 3110. What is this matter about?
Petitioner purchased a land, my lord. And after purchasing the land, subsequently the mutation was applied and the land was mutated in the name of the petitioner. But thereafter, my lord, one of his neighbor of the petitioner illegally trespassed upon the aforesaid land. We already informed the concerned authority, that is respondent number 3, circular officer, my lord. But respondent 2 and 3 still are not taking any step. Several time we giving the representation matter.
So what to do, Mr. Goswami? It seems that they are refusing to take steps.
Look.
They are refusing to take notice.
Look, see, direct to Raghunath Bhushar to demarcate their land.
Huh?
They can, taking the course of this office memorandum, they can demarcation.
What office memorandum?
That is there.
Yeah, fair is only for demarcation.
Demarcation.
Huh?
Yeah, fair is only for demarcation.
That's what. So we can ask the circle officer to demarcate. है ना? Correct. Heard, Mr.
B. Bora.
B. Bora, learned counsel for the petitioner. Mr. N. Goswami appears for respondent numbers 23, while Ms. G. Hazarika appears for respondent number 1. No one appears for respondents number 4, 5, and 6. Full stop. Notice had been issued twice upon the respondents number 4, 5, and 6 by a registered post with AD. The last one being issued on 3/2/2023. Besides the above, the petitioner had also taken steps for service of notice upon the respondents number 4 to 6 by way of dusty service. As this court had found it difficult to ascertain whether notice had been served by way of dusty service upon the respondents number 4 to 6 earlier, fresh steps were ordered to be taken by an order dated 31/10/2022. The petitioner has submitted an affidavit dated huh? Can't know the date. What is the date?
27/1/2020, my lord.
Rakesh. What is the date? The second copy is there. Dated nil February 2023, which shows that, which states that the respondents number 4 to 6 refused to take service of the notice. In view of the above facts, our notice is deemed to be served. This court is of the view that notice is deemed to be served upon the respondents number 4 to 6. Next para. The case of the petitioner is that he had purchased a plot of land measuring 3 kathas and 7 lechas covered by DAG number 1155 and Pata number 2056 at Chifsakar town under Nagar Mahal Mauja. Thereafter, the petitioner instituted a mutation case, white mutation case number 92/1986-1987, which was allowed in his favor, and his name along with the name of his brother and sisters were entered in the land revenue records against the said plot of land. As one of his neighbors had illegally trespassed upon his land, the petitioner approached the authorities with a prayer to demarcate his land. Though the respondent number 3 initiated a process to demarcate the said land by fixing 21/12/2010 for the said purpose, the process could not be completed due to the absence of the neighbors or neighbor out here, there's S.
Yes, neighbor.
Neighbor. Full stop. The petitioner's prayer in this writ petition is that a direction should be issued to the respondents number 2 and 3 to demarcate the petitioner's land, the petitioner's family land, and to restore possession of the petitioner's land after demarcation. Mr. N. Goswami and Ms. G. Hazarika, learned counsel for the respondent, submit that they have no objection if a direction is issued to the respondent number 2 and 3. Respondent number 3. Respondent number 3 or what? Respondent number 3 to demarcate the petitioner's land and take necessary steps thereafter. Full stop. Next paragraph. In view of the consent of the parties, the respondent number 3 is directed to demarcate the land belonging to the petitioner's family covered by measuring 3 kathas 7 lechas covered by DAG number 115 and Pata number 2056 in Sifsagar town under Nagar Mahal Mauja.
1155, my lord.
Huh?
1155.
1155 and 2056. And take necessary steps thereafter. The said demarcation should be concluded by the respondent number 3 within a period of
1 month from the date of the receipt.
1 month from the date of receipt of a certified copy of this order.
From the petitioner.
Huh?
They will approach Lordship.
Naturally. And after giving an opportunity of hearing to the other side, to the neighbor, to any person who has encroached upon the land of the petitioner's family. The writ petitions accordingly disposed of.
29.
Millie Hazarika. LR Mazumdar is for the council petitioner. Must have been complied with that. No one appears for the petitioner on call. List the matter on And, 3-5.
Content case, my lord.
What has to be done here? Like, where is the,
My lord, for updated, my lord, status, my lord.
huh? Which page? Where is the order?
Order is at page number 7, my lord.
7.
7, my lord. Functioning of bus stand at Moirabari town, my lord. There are many applications, my lord. But prior to consideration, some persons running a bus stand, and which we have silenced, my lord. And this honorable court person direction still an decision is arrived by the transport authority. No one shall be allowed to function the bus stand, but it was continued. Therefore, we filed this contempt petition, my lord. And what is the status now, my lord? We have no instruction, and the respondents had remain appeared, my lord.
Now it's come after, now who is the counsel for the other side?
Other side is my lord. Mr. Z. My lord, Y Dole and C Borua, my lord.
Huh?
Y Dole and C Borua. Other side is not present, my lord.
Then what to do?
Not any other date will.
Right, as no one appears on behalf of the respondents, this is the matter. When?
After 1 week, my lord.
After 1 week.
1 week, 10 days.
This is the matter after a week.
My lord.
The order has been complied with, Lordship.
Complied with, right, no one appears for the petitioner on call. Mr. N. Upadhyay appears for,
The respondent.
acha,
I'm appearing on behalf of M. Burman, madam. Madam, already speaking order has been passed, madam.
complied with.
Yes, ma'am.
Miss
And Fukan.
N. Fokan, learned counsel for the petitioner, and Mr. N. Upadhyay, learned counsel for the respondents, submits that the contempt petition has been closed, can be closed as the speaking order has already been passed. In terms of the order dated
Lordship.
10/12/2018,
Lordship.
passed in WPC number
6162/2015.
6162/2015. So accordingly, in terms of the consent of the parties, the contempt petition stands placed. In terms of the submission made, that possible. No one appears for the petition on call. This is the matter after 3 weeks.
Steps upon respond number 9, 10, and 11 have been taken, your lordship. But respond number 10, your lordship, you are unable to gather the name of the father's name, your lordship. And as such, your lordship, you are not able to take the steps upon respond number 10, your lordship. Your lordship, my prayer is that kindly the name may be struck and further proceeding may start, your lordship.
What is this matter about?
It's a matter, your lordship, regarding boy, your lordship, Rothin Das, the petitioner's son, your lordship. He has been missing since 2018, your lordship.
2018,
Yes, your lordship, and he is still untraceable, your lordship.
untraceable. So is this a habeas corpus?
It's a,
They're seeking CBI inquiry, Lordship.
we are seeking CBI inquiry, your lordship, to transfer the 2 FIRs of Jalukbari PS case number 1510/2018 and Jalukbari PS case number 1760/2018 to.
CBI inquiry for what? Because the son is missing.
Yes, your lordship.
So why CBI inquiry?
Because the lordship, the police is not taking any steps, your lordship, but not.
What do you mean not taking any
taking any proper investigation, your lordship.
So if there are 1,000 people missing, everyone CBI inquiry.
Your lordship, simple prayer, your lordship, because the petitioner a very poor person, your lordship, but
Maybe poor, so what? Maybe the richest person also. How does it matter? So only, so rich and poor, everyone should go for CBI inquiry for everything. Huh? Is that your case? Show me what's wrong what's wrong with the police investigation?
till now nothing has been recovered, your lordship, because your lordship, we have seen inquired.
May I submit, Lordship?
Huh?
May I submit, Lordship? I have been informed that case has been handed over to CID, Lordship, for investigation.
Yes, what is to be done?
I need some time, Lordship, because status of the investigation.
Mr. N. Goswami is granted 3 weeks time to obtain instructions with regard to the investigation conducted by the police with regard to the missing son of the petitioner. This is the matter of the 3 weeks.
Your lordship, the petitioner, response number 10 may be struck off, your lordship, because as we are not able to take steps upon response number 10.
We'll see, madam.
42. Obligation.
In this case, my lord, we need some time, my lord, after
What is this matter about? You have always adjourned.
Yes, ma'am, this is regarding one promotion to the post of grade 3 from grade 4, my lord. Actually, what happened, my lord, petitioners are from the personal post, my lord. Personal post
Then?
was dismissed.
Ah.
Therefore, they preferred an appeal also, my lord.
Ah.
In the appeal, there's a direction to review the order, my lord.
Ah.
That is there. But in the meantime, my lord, in the another case in another bench, my lord, regarding this personal post, my lord, matter was remanded to the government, my lord, for government to consider.
Show me.
Main issue was not this thing, my lord. In the main case, the challenge was with regard to the speaking order.
Petitioner pass out the time being also.
Just a minute. Yeah, what is this out here? Why did you come back to this court?
But,
Because of the division, it's the division bench order.
Division bench order.
Let us see what does the division bench say? Which page?
163, my lord.
163.
166, my lord.
Yes. Yes, so what do you want to raise now before this court?
But our, with regard to personal post, this is, I've fairly submit, my lord, and regarding my lord,
Your only ground is that they are personal posts.
personal.
So,
This is pointed out by my
so if
learned
they are
friend.
personal posts, they should be allowed to be promoted.
We are not praying for mandamus, my lord. We are not praying for mandamus, but observation from your lordship, as I have given the common order, one order.
I am bound by, this is, you see, this is Dilip Kumar was, there is a division bench order of this court. We are bound by the division bench order. This order does not bind this court at all. Division bench order binds this court. Now you see another thing, this is a funny anyway, what's gone is gone.
I'm
They,
praying for
they,
some accommodation.
you have made only one point before this court. That has been decided by this court. You go to the division bench and you say, yes, one point was raised, the one point decided, but I now want to raise new point. And the division bench sends it back. These points were never raised before the single judge review. How can that be? That is, I mean,
Points are, point, my lord, with regard to the
you
speaking
see,
order.
once you cannot raise one point here, then go to the division bench and say, these 2-3 points also I want to raise. And then the division bench sends it here, this 2-3 points should also be here. This is wrong. I don't agree to this.
Actually, our.
Otherwise, it will be never ending. Now what will happen is they'll go to the Supreme Court, say that 1, 2, 3 points were submitted, decided. But now we want to raise 0.5, 6, 7 before the high Supreme Court. Then they will send it. It will be never ending exercise then.
Our case was.
So now let us be clear. Again, I decide this point. You will go and say that, and now I want to raise fresh points.
My lord.
And it will be never ending.
Our.
This is. I'm sorry to say, this is not the way.
Main challenge is with regard to Annexure 9, page number 120, my lord.
Huh?
Page number 9, Annexure 9, page number 120.
Annexure 9.
Annexure 9.
Page 120.
Yes. What happened, my lord? This was passed. This speaking order was passed by the government, my lord, pursuant to direction of another writ petition.
Just a minute. Where is the 120?
Yes.
Well, this has all been dealt with.
No, you see, now your only case before this court is with regard to that persons who are having personal posts can be promoted. That's a case.
That is one part, my lord.
And what is the second
another
part?
part is, my lord, Annexure 9, page 122. That is includes speaking order. That is 120. That is passed by the government, my lord, whereby they have stated that the Assam Ministerial District Establishment Service rule will be applicable.
Will be applicable for what?
For promotion to the post of.
It will be applicable, but
No,
provided
but-
it is in consonance with the.
No, my lord. There are other independent service, draft service rule is there in respect of PhD department, my lord, which does not provide, my lord, the minimum qualification should be graduation for the post of.
Does this Assam Ministerial District Establishment Rules 1967 provide for promotion for persons having personal posts?
That is not there.
Then
That is not there.
now in your case, you are all master roll employees who are regularized.
And our promotions earlier dealt with.
Well, this is a review, madam, confined to order 47 rule 1, madam.
Correct. You
That's
cannot have
nothing
a. That is what, and this was never an issue raised by them. Anyway.
In fact, my lord, when this motion was moved, that part was never revealed that they were master locals. Only upon deliberation, my lord, we came to find out, madam.
Okay, fine. No, but then with this court, while disposing of this writ petition in the earlier round, if you see the order
Yes, ma'am.
passed, this has been stated.
Yes, ma'am.
With respect to persons who have been regularized against personal posts, whether personal posts can be promoted, this court in its judgment and order censor has held that persons regularized against personal posts do not have any right to be promoted to a cadre post, in as much as they are the post they are holding are ex-cadre posts.
It is
It's
based
clear.
on Dilip Taluk, where my lordship was also part of that bench, madam,
Ah.
with Justice Sailwa. Dilip Taluk's case, squarely covered, madam.
That was not the issue. That is raised by the learned friend, my lord. That was not the issue in the writ petition. We came.
No, no, you see, at the end of the day, the division bench judgment of this court is still holding the field. What more do you want? Right. Heard Mr. B. Purkaisa, learned counsel for the petitioner, who submits that the present review petition has been filed in view of the order dated 29/7/22 passed in WA number 238/2022. Wherein the division bench held that it would be appropriate for the review petitioners to approach this court by way of an appropriate review petition, as the questions raised in the appeal were not raised before the learned single judge. It was not raised before the learned single judge, that is this court. So, stop. Mr. D. Gogoi, the learned, no, before that, you right? Mr. B. Purkaisa submits that the question that is sought to be raised before this court is that a person who has been regularized against a personal post can be promoted from a grade 4 post to a grade 3 post in terms of the Assam Ministerial District Establishment Service Rules, 1967. That's your case.
But I have, my lord, my submission is that there is a departmental rule, service rule, my lord, that is not followed, which does not provide that the graduation should be minimum qualification for the post of grade 3. That is the case, my lord.
Huh?
For the post of Assam 1967 rule prescribes, my lord, for graduation should be minimum qualification for the post of grade 3 employees for promotion. But as public PhD health, PhD department rule, my lord, that doesn't provide so, my lord.
But that part remains, my lord, grade 3, but my lord, they are these employees, my lord. That
Under
remains
that
their
rule, my
personal
lord,
post,
under that rule.
Which rule? Which rule is that?
That as a public health engineering, the department grade 3 and grade 4 field level employees, non-gazetted service rule, my lord.
Where is that? In which page?
Page 87, I have given the. Starts from page
So,
85.
so you're not submitting with regard to Assam Ministerial District
No.
Establishment Service.
This rule does not, my lord, provide that for the promotion, graduation should be the criteria. That doesn't provide so. In respect of PhD department, my lord. And further, my lord, there is
No. So according to you, you don't need to be a graduate to be promoted.
yes,
You're not talking about personal post or not.
yes.
That's fact. Okay, what have I said?
To submit that the question that is sought to be raised before this court is that a person who has been regularized.
No, is that in terms of the Assam Ministerial District Establishment Rules 1967, the minimum educational qualification for promotion to a grade 3 post is graduation. Full stop. However, in the which department?
Page 85, my lord, in the public health engineering department, grade 3 and grade 4 field level employees, non-gazetted services.
However, in the Assam Public Health Engineering Department, grade 3 and grade 4 field level employees, bracket non-gazetted service rule, there is no requirement for a candidate to be a graduate for promotion from a grade 4 to a grade 3. Is this rule, is this page 85, is this rule Gazetted? Is it gazetted in the thing? Same gazette?
Not gazetted.
Then
my lord, they are following this rule, my lord, for last 20 years.
That apart at the threshold, he has to satisfy whether he is eligible for promotion or not. He is holding a regular post, my lord.
Correct.
My lord,
Push up,
further one another submission we recorded, my lord, and there is no regular post, my lord. Even in the my lord PhD department under this rule, there are grade 3 and grade 4 posts are shown, my lord. All the posts are personnel post, my lord. They are promoted from one post to another post, personnel post. Also. Earlier occasions in PhD department. my lord.
he further submits that the Assam Public Health Engineering Department grade 3 and grade 4 field level employees bracket non-gazetted service route, hereinafter referred to as the non-gazetted service route, has not come into force by publishing the same in the official gazette. So, however, the same is being applied by the state respondents for promoting grade 4 employees to grade 3 posts in the Public Health Engineering Department, Assam. He accordingly submits that the petitioners who are holding grade 4, who have been regularized to grade 4 posts against personal posts should be promoted.
Then names have been
Should be
recommended.
promoted to grade 3 posts in terms of the non-gazetted service route. Next para. Mr. D. Gogoi, the learned counsel for the PhD department, submits that the
My lord, their names have been recommended for by the TPC, my lord, page 126.
maybe. No, okay, one thing you just write, one more thing. The petitions council further submits that the names of the petitioners have been recommended for promotion. Page?
Page 126, my lord.
Recommended for promotion to grade 3 posts by the selection committee in its meeting minutes dated 13/8/2020. Then Mr. D. Gogoi, learned counsel for the PhD department, on the other hand, submits that in terms of the division bench judgment of this court in Dilip Talukdar and 21 others versus State of Assam, reported in 2017 to GLT 135, it has been held that persons who have been regularized against personal posts cannot be promoted from grade 4 to a grade 3 post, as persons regularized against personal posts are holding ex-cadre posts. As such, they cannot be promoted to a cadre post. Next, he accordingly submits that the writ petition should be full stop. Mr. D. Gogoi further submits that when this court had dismissed the case in the earlier round on the only contention raised by the petitioner what have I said? Just it.
If further submits that this court had when this court had dismissed the case in the earlier round on the only contention
on only one question raised by, only one contention, only on one contention raised by the petitioners, comma, the petitioners could not have challenged the decision of this court before the appellate authority on some other contention, comma, that had not been pressed in the earlier round. Full stop. I have heard the learned counsels for the parties. Just say, hearing concluded, order reserved. I have to make it very clear.
Review, my lord, sir, review grounds are very clear. my lord.
No. But what to do? That order is there from. It has,
There is,
because that the reason for dismissing the writ petition has not been set aside by the appellate court.
Yes, my lord.
It has, the appellate court has said that the ground that is being urged before the appeal court has not been urged before the single judge. So we're sending it back so that the single judge can also discuss this. But what about the earlier dismissal? Earlier dismissal is also still in force.
My
Where is the case? I don't know.
lord. my lord.
Can you put this up?
Yeah, please, your lordship. My lord, in 43. My lord, the factual background of the review petition is that, my lord, she was appointed as a Anganwadi worker in the year 3/3/2007. And her salary was
This will take some time, I think, huh?
My lord.
It should not take that much of time, but it was, yeah, it had been, rejected, dismissed, and then.
The review was also, my lord, the subsequent writ petition was also dismissed.
So everything has been restored now.
My lord, there was an order, previous order, to obtain staff, whether the post is filled up or not.
Has the post been filled up?
No, that information we haven't received. We have
You see,
already
that is going to be very important.
vital, yes, because
Because
ultimately.
if that post has been filled up in terms of the advertisement, 2019 advertisement, then either we implead that person who has been appointed, or we can pass, order, we can dispose of the matter. So that is one thing. Otherwise, if we have a hearing now, and then we later find that somebody has already been appointed to that post, that's going to might create a problem.
Okay, these two previous writ petitions, one is with regard to continuation and another is with regard to salary. So that I think that salary, writ petition relating to the salary would hardly have any impact upon this dismissal order. But still then, I will try to figure it out and find out what is the present status, whether anyone has been absorbed. in
Only that.
Yes,
That
only.
last order is there. When can you get the information?
Just 2 weeks, 2 weeks time. 2 weeks.
Mr. S. Barwa.
Date may be fixed.
Mr. S. Barwa, learned counsel appearing for the Social Welfare Department.
For the state government.
For the?
State government.
So then we need from the social welfare. We don't
No,
need from.
we are appearing for the state government. all
Okay, fine.
associates.
Appearing for the
All the
social, for all the respondents. And submit that he will obtain instructions as to whether the post of Anganwadi worker has been filled up in terms of the advertisement dated 8/2/2019. Comma, which is reflected in para 8 of the order dated 27/7/22, passed in WPC number 4773/22. This is the matter on, give a date.
On 10.
This is the matter
10.
on third,
Yes, third.
or otherwise it'll have to be in May.
Let it be on 10th of April, 10th of April. 10th of April.
10th of April.
Or else it has again to go post the vacation.
10th
Okay, 10th April.
Bibliography.
Yeah.
Please, Your Lordship. Lordship, as per Lozima Court Order, Your Lordship, 14/3/2023, Your Lordship. The respondent number 6, Your Lordship, his name is reflected. He is well represented by showing the name of the advocate, Your Lordship. So, Your Lordship, regarding the petition 709/2022, that service is completed, Your Lordship.
In fact, I have received a brief instruction. So here the petitioner has been claiming that he has filed representation before the superintendent of police and also the deputy commissioner as regard the mental harassment that has been meted out. But from the records, the office says that no such complaint petition has been lodged by the petitioner. So the records speak differently.
As per instruction, they filed a complaint, Your Lordship.
Let him produce a receipt copy if at all he has filed any such formal complaints.
If Your Lordship petitioner filed a complaint, then date may be fixed, then I will produce the receipt to Your Lordship as per instruction. And regarding 47, Your Lordship, it is you may be directed to take first steps upon 8, 10, 11, and 14, Your Lordship.
You have filed a complaint to whom?
Deputy Commissioner.
Where is that complaint? Page?
Lordship, next up 4.
Now what to do? They're saying that you have not filed a complaint.
What a time may be given to verify whether he has already filed the complaint or not. Because as per instructions, he has filed the complaint, Your Lordship.
There must be a receipt somewhere, no?
Yes, Lordship.
Hmm? There's one seal out here. Seal is here at page 39. But who has given the seal?
That perhaps that is with regard to the complaint before the deputy commissioner.
Yes.
Yes, but the superintendent of police Golaghat hasn't received any such complaint. So that the inquiry can be gone into, because ultimately it is a case of mental harassment.
Superintendent of Police, here is a annex of 543. Please. Here is the signature receipt. The right hand side, Your Lordship. 43.
But then it is not showing. There is, how can it be? There's half, only half.
My lord, in this case, my lord, I am appearing on behalf of the respondent number 5 in the first case and respondent number 6 in the second case. All the allegations is against me, Your Lordship. And after filing my Wakalatnama, this case was come up for the first time, my lord. I also need some time to file my affidavit in opposition, my lord, because I have to counter the allegations, my lord.
Okay. Okay, right.
Only, my lord,
Huh?
only my prayer is that only 4 weeks time may kindly be given, because I have
Mr.
D. Barwa.
D. Barwa, learned counsel for the petitioner, shall produce proof that complaint had been submitted to the Golaghat police station on 9/12/2021. Mr.
M.A.I. Hussain.
M.A.I. Hussain, no, before that, this is due to the fact that the parawise comments received by Mr. S. Barwa, learned counsel for the state government, is to the effect that no complaint has been received by the Golaghat police station. Full stop. Mr.
M.A.I. Hussain.
M.A.I. Hussain, learned counsel for the respondent number 5 in WPC number
709 of the 2022.
709/2022 and respondent number 6 in 282/22. Submits that he will file affidavit in opposition within
4 weeks, my lord.
4 weeks. Mr. D. Gogoi.
Is T. Tarun Gogoi, Your Lordship.
Tarun T. Gogoi.
Respondent number 6 in first and the item number 46 and respondent number 15 in.
Are you filing anything?
Lordship, will file.
Counsel for the respondent number 5 in 709 and 6
Yes.
in 709 and 15 in 232 is also granted 4 weeks time to file affidavit position. This is the matter after 4 weeks.
Yes, please, Your Lordship. Item number 48.
Yes.
We are in new sets of advocate.
Huh?
We are in new sets of advocate for this case, and we have filed the Wakalatnama today. So kindly, the matter may come up after we will.
Yes, madam.
Lordship, I have obtained instruction and I have filed affidavit also. Lordship, kindly see in my affidavit at page 9, Lordship. Sorry, 4.
Yes.
Para 9.
Yes.
Deponent states that vehicle is in safe custody of Kamrup Metropolitan Excise at present. And the undersigned, with utmost humility, would like to point out that this IMF is assumed to be spurious in nature and can cause threat to human life. The understanding is of the law that the vehicle should continue to remain in custody of Excise Department until the receipt of chemical analysis report, Lordship. And according to
Where was this seized? Where was the vehicle seized?
vehicle was seized. While it was coming from
When? I said when.
when
15/9/21.
yes.
Has complaint been filed?
Lordship, sorry.
Has a complaint been filed by the excise department?
Yes.
Charge sheet complaint, has it been filed?
Sir, see,
You
Lordship,
see, charge
at
sheet cannot be
present-
filed by excise. It has to be, I think a complaint has to be filed
Yes, Lordship.
under 195. Nah? Then has it been filed?
Complaint as. But Lordship, confiscation process hasn't started.
Confiscation under what? Under which law?
Under section 74 of the Assam Excise Act, this vehicle is liable to be confiscated, Lordship. It clearly states that any animals, skirts, vessels, rafts, or other conveyances used in carrying any objectionable goods is liable to be liable for confiscation, Lordship, under section 74D of Assam Excise Act.
Who will do that? But the department will do it or the court will do it?
Department investigation.
Show me the law. Show me your excise act.
Lordship, kindly give me some time, Lordship. I will show it next time, Lordship. And they have given me the verbal instruction at present. I'll show you the documents.
Madam, you are supposed to be the counsel for the excise. You are supposed to give them advice. You are supposed to be knowing what's going on.
Yes,
Then
Lordship, I have asked them, they will produce.
you are supposed to be advising us also, telling us.
Kindly 2 weeks time will be given, Lordship.
Why should it not be released on Zima?
Lordship, because Lordship, the finding of the investigation gives a hint of involvement of the petitioner, that means registered owner of the seized vehicle, with the Ellis offense, because
Right, on the other parties, this is a matter after 2 weeks. Next.
driver Alifuddin, Lordship,
Next.
obliged, Lordship.
But this is a review application filed by the state. But we have prayed for review of the honorable court order at page 22, order dated 31/3/2022.
22.
Logic 31/3/2022. But in fact, facts are admitted. The ground of review is not.
Just a minute.
Lordship, in this case, I have instructions to appear for the respondent number 1. Wakalat number today. We'd like to file an affidavit excelling the maintainability of this review petition, Lordship. Lordship, can it be fixed on the 3rd of May, Lordship?
Yes, sir. Okay, heard Mr.
I'm Dina.
Dina, Learned Counsel for the review petition, who submits that the judgment in order dated 31/3/22 passed in WPC 5158/2021 should be reviewed. In as much as, why?
Look, the respondent number one here and the petitioner, he is an employee of the Deputy Commissioner's office, DC office. Look, and the promotion is, look, this particular post belongs to the Directorate of Food and Civil Supplies. Those are two different departments. Look, even if in the amalgamated establishment there is a branch, in that branch he has been posted for the test as a stopgap arrangement. Look, he is serving under in that branch. That doesn't mean that he will be promoted in the Directorate of Food and-
In a post for the.
of a different department. Because the rule,
In as much as the petitioner who is working in the establishment of the Deputy Commissioner, Dubri, cannot be considered for promotion belonging to the Directorate of
Food and Civil Supplies.
Food and Civil Supplies. Issue notice returnable in 4 weeks. Mr.
M. Das.
M. Das accept notice on behalf of respondent number 1. And submits that he wants to file an affidavit
Challenging the maintainability of the.
challenging the maintainability of the review petition. Anybody else is here?
Lordship, the former respondent is the Deputy Commissioner.
DC is a performer.
Mr. S. Barwa accept notice on behalf of the performer respondent number 2. Who is the Deputy Commissioner? List the matter after 4 weeks.
Can I pray for a fixed date? Lordship?
Huh?
Can I pray for 3rd of May? Lordship?
No.
Obliged.
This is an 18 matter, there is an interim order. One house is operating and there are prior respondents in the play. They are stating that the NOC signatures were taken by the licensee are forged, your lordship.
Now, what is to be done?
Petition, even the petition not your lordship. I was thinking of let the additional commissioner of excise.
Huh?
Let the commissioner of excise verify the records, your lordship, the signatures which are given by the licensees on the NOCs. Where the prior respondents are saying that the licensee, the signature are forged, your lordship.
Who is saying the signature is false?
The prior respondent.
Huh?
The private respondent, your lordship.
I'm a private respondents, my lord. The signature which was, my lord, there in the NOC, my lord, except, my lord, 1 and 10, my lord, all are forged. And one of them, my lord, my lord, the signature was forged, my lord, they are also filed a criminal.
Please come here. I can't hear you.
May I please, your lordship? May I pray your lordship to take the IA, my lord, which I had held.
Give me the eye.
My lord, to dispose of, my lord.
I is not listed today.
Lordship, my lord, here, my lord, what are the-
I is disposed of.
Dispose of, my lord, why am, my lord, you're placing this, my lord, I have, because, my lord, in that, my lord, I have placed some documents, my lord. And in fact, my lord,
No, what can be done today in the absence of the petitioner?
it is up to
Huh?
your lordship, my lord, your lordship may.
Right. No one appears for the petition on file. In the interest of justice, this is the matter after review.
May I please, your lordship?
Yes,
Lordship, we are required to file our affidavit, my lord.
so
My lord, sometime maybe we can have it.
what has happened to this tender notice? Who is appearing for the Khadi and Village Board?
My lord, we,
You. What has happened? The 2018 tender notice, is it still valid? You've got no idea. Completely no idea. 2018. This tender notice of March 2009, March 2018. And then thereafter, there was a notice inviting quotation on 11th April 2018.
my lord, matter may come up next week, my lord. We will get instruction. We'll take instruction.
Yes, why are you challenging this? What is your ground for challenge this notice inviting quotation?
So they have a EU lordship will find. Yeah, earlier they have filed a quotation, but subsequently they have filed another quotation.
So what is wrong?
But
What right of yours has been violated?
because without closing of the earlier tender, your lordship, so they cannot by closing that tender, they cannot file another tender.
Why?
your
Who
lordship.
says that? Under what law is that? Who says that they cannot do it? It is their money, they can do whatever. Did you
No,
submit?
under registered contractor, under
You
under
may
them.
be.
But
You may be.
even then they are not.
There's no right accrues to you. Just tell me one thing. Did you submit your tender with your bid with regard to the earlier tender notice? There were two tender notices. One is of March, one is of April 2018. Did you submit your quotation with respect to the first tender notice? Did you submit?
My lord,
Where have you stated that?
I have submitted.
Where have you
I
stated
have
that?
submitted the code.
Let us see.
My lord. The respondent number 3 para 3 will the respondent number 3 issued a tender dated 9/3/2018 to supply cells the book for containing page 1 to 300 of 2000 numbers quantity and personnel ledger book containing page 1 to 300 of 2000 200 number quantity, and as such the petitioner has submitted the tender to the corresponding authority, your lordship. And Annexure 7, your lordship. Page 7, your lordship, Annexure 1. Then paragraph 4, your lordship, the respondent number 3 has issued another tender notice, your lordship. 11/4/2018 to supply the same as above without assigning any reason to supply the articles to the respondent number 3, and which will be open on 24/2018, your lordship.
Tell me one thing. How does it prejudice you? You have submitted a tender.
Without opening your earlier tenders, how they have filed?
No, you see, if they have
another
opened it,
tender, your lordship.
no, no,
I am
you-
the registered contractor of the department.
if they have not opened the earlier tender,
My lord.
then what right of yours has been violated? If the earlier tender had been opened, you were found to be the lowest tenderer, and then they issued another advertisement, then you can say, yes, my right has been violated.
No, I may be lawyers or higher that without opening the tender, how it will decide it? That
No,
tender
if
should
they,
be open, your lordship.
no, no, no. Where?
Tender should be
Show me the
open.
law. Show me the law. There's no law.
Then you lordship will fix another date. I shall produce the law, your lordship.
We'll list it day after tomorrow. You bring it day after tomorrow, the law.
Tomorrow, after vacation, you.
No,
lordship
no,
will
no,
file.
no, no.
I'll-
You
I'll submit.
cannot dictate.
Because till then they have not filed affidavit even. Let them to file affidavit. They have not even filed affidavit. There is a stay order, your lordship. Your lordship will, there is a stay order. Your lordship. Order dated 27/4/2018. Your lordship.
Oh, no order awarding contract. Okay, anyway. Just tell me one thing. Why is this? I don't know. He's got. I don't find any right of way has being violated. But that being said, what has happened? This cannot go on. It is because of the stay order. Nothing is happening. This cannot go on. 2008 matter, 18 matter. Now 5 years have passed. 5 years then, and it's a supply of books. What right?
That should be stop, your lordship. As per there is an interim
No,
order,
no,
your
no.
lordship. There until next date fix.
No, no, no.
Order awarding
Mr.
such and such.
Mr. Chowdhury,
My lord.
maybe. But you see, you have got to show that some right of yours has been violated.
Then after vacation, your
No,
lordship will
no. Why should we keep on? They want to supply something. Let them float a new tender. Then no, Mr.
they
Council,
may-
please listen.
My lord.
Let them float a new tender. Then you can file your quotation. How does it matter?
How,
Now,
your lordship,
can you supply books at the 2018 rates today?
No, that should be, they have not filed even any affidavit till today, not by clearing. What happened at present, your lordship. Let them to file affidavit, your
You
lordship.
see, Mr. Council, I'll tell you why. Since 2018, the last time this case was listed was in June 2018. It is not because of their fault, because the case was not listed before this court.
Let the matter be listed.
Anyway, you
let-
obtain instructions. You say, Mr.
A Gayan
A. Gayan,
for respondent number 1 and 3.
respondent number 1 and 3 shall obtain instructions with regard to this case. List the matter on Thursday, this Thursday. This Thursday.
Must oblige.
Thursday, I am.
You are not there
I have
then,
some problem, your lordship. Thursday, I have. another-
Okay, Wednesday, list the matter
So
Wednesday.
then I-
Wednesday.
In fact, to be very frank, here, the respondent number 1 has been made the state of Assam represented by the chairman, Assam Khadi and Village Industry. How can it be complete? Respondent number 1 is said to be the state of Assam, whereas it is being represented by the Khadi and Village Industry.
It cannot be.
It cannot.
Cannot be.
He has to first correct that.
You cannot represent. Who are you representing?
No, I've said similar chairman. that is for Assam Certificate.
No, this writ petition is wrong. Also.
It is wrong.
There's nothing in this writ
There is
petition.
nothing.
There's nothing in
There is
this writ
nothing. In fact, it
petition.
In fact, I am remotely associated here because our Director of Information and Public Relations is made a party. I don't know why.
Let us see, Chief Executive Officer.
Yes. In fact, the necessary parties are the chairman and the chief executive officer of Khadi and Village Industry, whereas it has been wrongly noted as the state of Assam.
There is nothing in this writ petition.
Nothing.
No right has been violated. No one's right has been violated, actually. Okay, right, we'll dispose of this. No point keeping it to
There's no
heard
point.
Mr. R.M. Chaudhary, learned counsel for the petitioner. Also heard Mr.
As Burwa.
You,
A Gayan.
A. Gayan for
Respondent number 3.
respondent number 3. Mr. S. Barwa appears for respondent number
2.
2. Full stop. Mr. R. M. Chaudhary, the learned counsel for the petitioner, submits that the petitioner had submitted his quotation in pursuance to a tender notice dated 9/3/2018 issued by the respondent number 3 for supply of sales daybook, SALES daybook, and personal ledger book numbering, no. You say sales daybook, 200 sales daybook and 200 personal ledger book, okay? However, even before opening the quotations of the petitioner and the other tenderers, the respondent number 3 issued a notice inviting quotation dated 11/4/2018, calling for quotations for the same quantity of materials mentioned in the earlier tender notice dated 9/3/2018. The petitioner's counsel submits that the issuance of the subsequent notice inviting quotation dated 11/4/2018 without opening the earlier quotations made in terms of the earlier quotation, in terms of the earlier tender notice, was arbitrary and illegal. He accordingly submits that the notice inviting quotation dated 11/4/2018 should be set aside. Next, Mr.
A. Gayan.
A. Gayan, learned counsel for the respondent number 3, submits that he does not have any instructions with regard to the above issue. Mr. Next para, Mr. S. Barwa, the learned counsel for the respondent number 2, submits that the petitioner has made the state of Assam the respondent number 1. However, the state of Assam has been stated to be represented by the chairman, Assam Khadi and Village Industry Board, and not by any commissioner or secretary to the government of Assam, which is improper. He submits that a perusal of the writ petition does not show that any right of the petitioner has been violated. Full stop. I have heard the learned counsels for the parties. Full stop. As can be seen from the pleadings and the submission made by the counsels for the parties, the calling for rates for supply of 200 numbers of sales daybook and personal ledger book while the earlier tender notice dated 9/3/2018 and subsequent notice inviting quotation dated 11/4/2018 are the same. Full stop. Though the petitioner had submitted his quotation in terms of the earlier tender notice dated 9/3/2018, comma, no quotation in pursuance to the said tender notice dated 9/3/2018 has been opened by the state respondent. Full stop. In that view of the matter, comma, there would be no bar for the petitioner. There could have been no bar for the petitioner to have submitted a fresh quotation with the same rate or different rates in pursuance to the notice inviting quotation dated 11/4/2018. The earlier tender notice not having been opened. No, not just that. The quotations pertaining to the old tender notice not having been opened, comma, no right of the petitioner can be said to have been violated. Full stop. Next para. It is also noticed that the last time this case was listed before this court, comma, prior to this date, comma, was on 13/6/2018. Full stop. More than 4 years have elapsed from the date of submission of the, from the date of, from the date of last listing. Full stop. In view of the above, comma, this court is of the view that pendency of the, no, yeah, in view of the restate above, comma, this court is of the view that keeping the case pending would not be in the interest of the public or for any person. Full stop. Accordingly, comma, the respondent number 3 is given the liberty. No, according to the respondent number 3. No, just say, accordingly, in view of the peculiar facts and circumstances of this case, comma, the respondent number 3 is given the liberty to carry on with the notice inviting, is given the liberty to complete the process for issuance of a supply order in terms of the notice inviting quotation dated 11/4/2018. Full stop. However, the petitioner herein should be given an opportunity to submit his quotation in pursuance to the notice inviting quotation dated 11/4/2018. Full stop. In the alternative, the respondent number 3 is also given the liberty to cancel the notice inviting quotation dated 11/4/2018 and call for a fresh tender notice, comma, keeping in view that the rates for supply of the books required would have changed as more than 4 years have passed from the date of publication, from the date of issuance of the notice inviting quotation dated 11/4/2018. As no right of the petitioner has been violated by the respondent in the respondents issuing the fresh notice inviting quotation dated 11/4/2018, comma, this court is not inclined to exercise its discretion in the present case, so the writ petition is accordingly dismissed.